the materials to members and staff as quickly as we can. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings. Everybody attending this hearing is required to follow this guidance. This is for the health and safety of all of us in this room, including our staff, and for the loved ones we will return to at the end of the day. I expect all members on both sides of the aisle to wear a mask, except when you are speaking. I will now recognize myself for an opening statement.
Mr. Chairman, point of
Last
parliamentary
Friday,
inquiry.
without explanation, Attorney General William Barr
Mr.
announced that Geoffrey Berman, the United States Attorney for the Southern District of New York, was, quote, stepping down, unquote. This was, of course, untrue. Mr. Berman had not resigned. In a statement, Mr. Berman made clear that he had no intention of resigning and every intention of moving forward with his work without delay or interruption. He emphasized that point. He wanted to stay on the job to ensure that his work would continue unimpeded. In order to understand the stakes in this standoff, it is important to note that the work of Mr. Berman's office has included a number of criminal investigations aimed at individuals close to President Trump. Among them, the President's attorney, Michael Cohen, the President's inaugural committee, and Rudy Giuliani, the President's current counsel, campaign advisor, and direct line to Kiev. On Saturday, Mr. Barr attempted to fire Mr. Berman directly. Even then, Mr. Berman resisted. Only when he was certain that his deputy, a qualified career prosecutor, would take his place as acting U.S. attorney, did he relent and step aside. So what are we to make of these events? If this had been an isolated incident, if the Attorney General had simply misjudged the situation and thought that Mr. Berman would go quietly, then we might chalk up this episode to simple miscommunication and incompetence. But make no mistake, this was not an isolated incident. The effort to remove Mr. Berman is part of a clear and dangerous pattern of conduct that began when Mr. Barr took office and continues to this day. Mr. Barr's actions make clear that in his Department of Justice, the President's allies get special treatment. The President's enemies, real and imagined, are targeted for extra scrutiny, and the needs of the American people and the needs of justice are generally ignored. Mr. Barr's practice of using the department to shield the President and his allies goes back to the beginning of his tenure at the DOJ. Last year, when the special counsel had completed his investigation, when Mr. Barr had the report in hand, but before the public could read it, the Attorney General blatantly mischaracterized the special counsel's findings, and he did so on the President's behalf. Among other deceptions, Mr. Barr pretended that compelling evidence of obstruction of justice, including evidence that the President may have lied directly to the special counsel, simply did not exist. Mr. Barr's deception seems blatant, but don't take my word for it. The special counsel wrote to Mr. Barr directly to complain about the inaccuracies which lingered uncorrected for weeks. A federal judge later said that Mr. Barr's inconsistencies were so distorted and misleading that he questioned Mr. Barr's credibility and in turn could not trust the department's assurances to the court about the contents of the Mueller report. Mr. Barr has also worked to undermine the criminal cases stemming from the special counsel's report. Early this year, after the President's associate, Roger Stone, was convicted of obstructing justice, Mr. Barr overruled his career prosecutors and recommended a lighter sentence for President Trump's friend. One of those prosecutors, Mr. Zelensky, will testify today about that experience. We should be clear about the timeline in the Stone case. If nothing else, it helps explain why Mr. Berman refused to go quietly over the weekend. In January, Mr. Barr removed the U.S. Attorney for the District of Columbia and replaced her with his longtime aide. In February, President Trump tweeted his feelings about Stone's ongoing criminal case. The President was outraged that Mr. Stone, his friend, might be punished for obstructing justice. Quickly thereafter, Mr. Barr reached into the case, overruled his prosecutors, and submitted a wildly lenient sentencing recommendation for Mr. Stone. All four prosecutors involved in the case, including Mr. Zelensky, immediately withdrew. The next day, President Trump tweeted his congratulations to Mr. Barr. The Stone case wasn't an isolated incident either. In May, Mr. Barr abruptly reversed course on the prosecution of Michael Flynn, the President's former national security advisor, who pled guilty to lying to the FBI about his conversations with the Russian ambassador. Once again, the President tweeted his feelings about the case. Once again, Mr. Barr reached into the proceedings, overruled his career prosecutors, misrepresented statements by department officials, and asked the court to dismiss the charges against Mr. Flynn. And once again, the President tweeted his delight at the outcome. Former federal judge John Gleeson, appointed by the court to account for Mr. Barr's unprecedented motion to dismiss the case against Mr. Flynn, argued that, quote, the facts surrounding the filing of the government's motion constitute clear evidence of gross prosecutorial abuse. They reveal an unconvincing effort to disguise as legitimate a decision to dismiss that is based solely on the fact that Flynn is a political ally of President Trump. Judge Gleeson was not alone. Days after Mr. Barr insisted on dropping charges against Mr. Flynn, almost 2,000 former FBI agents and Department of Justice officials wrote an open letter calling for the Attorney General's resignation. Now, my Republican colleagues may try to explain these incidents away. They may tell you that Barr's attempts to fire Berman were harmless, that Flynn and Stone should be excused for their crimes, and that Mr. Barr's extraordinary attempts to protect the President from criminal liability are necessary to correct for a vast conspiracy at the Justice Department. Those excuses ring hollow. There is injustice at the Justice Department, ladies and gentlemen, as there is extensive injustice in our justice system nationwide. We have rightly focused on one major aspect of that injustice in recent weeks, since the murder of George Floyd at the hands of law enforcement officers. But as we prepare to address that injustice on the House floor, in the single largest and most sweeping package of police reforms in our country's history, I cannot help but notice that the members who tend to shout loudest about hoaxes and witch hunts also stand in opposition to these common sense reforms. Ask yourselves, what are you saying to the American people when your commitment to justice means that you will stand up for Flynn and Stone and Barr, but go no further? No, Mr. Barr's work at the Department of Justice has nothing to do with correcting injustice. He is the President's fixer. He has shown us that there is one set of rules for the President's friends and another set of rules for the rest of us. And to be clear, there are plenty of reasons to be angry with Attorney General Barr. It is unacceptable that he would order the Antitrust Division to initiate pretextual investigations into industries that he and the President do not like, simply because they do not like them. Mr. Elias will testify to that abuse today. It is dangerous and misguided for him to threaten frivolous litigation against state and local officials doing their best to contain the COVID-19 epidemic in their communities. It is simply irresponsible for him to do so in the total absence of guidance from the White House or leadership from the President. And it is outrageous that Mr. Barr occupied this city with a federal police force outfitted in paramilitary gear and then turned that force on peaceful protesters in Lafayette Square, spraying them with tear gas and physically knocking them back, all to arrange for an awkward photo op for President Trump. The images from that day are so disturbing that we cannot blame Mr. Barr for trying to avoid responsibility for his role in the event in the days since. But please understand that these are merely the symptoms of an underlying disease. The sickness that we must address is Mr. Barr's use of the Department of Justice as a weapon to serve the President's petty private interests. The cancer that we must root out is his decision to place the President's interests above the interests of the American people. Our witnesses today will speak to the extremes to which Mr. Barr has reached to carry out the President's bidding. I am especially grateful to Mr. Elias and Mr. Zielinski, who are current department employees, for their bravery in appearing before the committee. This administration has a record of witness intimidation, and I have no doubt that they will try to exact a price for your testimony. But you are patriots, and you have done your duty here today. It gives me hope for what may come at the Department of Justice when Bill Barr is finally removed. I thank the witnesses for being here today, and I look forward to your testimony. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. The Bar Justice Department is about correcting injustice. I mean, the very day, you almost have to laugh at this, the very day you have a hearing going after the Bar Justice Department and alleging that there's politics involved there, the very day we get the order from the United States Court of Appeals. The order says, dismissing the Flynn case, the district court is directed to grant the government's motion to dismiss. The district court's order appointing amicus is hereby vacated. I mean, they're not political, they're just right. If there's any politics, I mean, again, you almost have to laugh if it wasn't so serious. The politics, Attorney General Holder said he was Obama's wingman. The Obama-Biden Justice Department attacked investigative journalists. Here's what one of them said. James Risen with the New York Times said this: if a president throws a whistleblower in jail for trying to talk to a reporter or gets the FBI to spy on a journalist, he will have one man to thank for bequeathing him such expansive power: Barack Obama. That's not me talking, that's James Risen of the New York Times when the Justice Department, the Obama, Holder, Biden Justice Department, went after him. Of course, we know about Fast and Furious, we know about Operation Choke Point, and even though Chairman always doesn't want to talk about this, we know how political the Justice Department was in the whole Russian hoax, the whole Trump-Russia investigation. Remember this: the Obama-Biden Department of Justice spied on 4 American citizens. That's the big thing you guys have with Bill Barr, too. First time he testified in front of the Senate, he used the word spying, and everyone went crazy. But he used the word spying because that's exactly what happened. They spied on 4 American citizens associated with the presidential campaign. An investigation we now know was completely bogus because Rick Grinnell released all the transcripts from all the people who were involved in the intelligence community in the previous administrations, and they all said there was nothing there. The Obama-Biden Justice Department, in order to spy on those Americans, what did they do? They lied to the FISA court 17 times. They used the now famous dossier, the dossier that Jim Comey, not Jim Jordan, Jim Comey said was salacious and unverified. They didn't tell the court the guy who wrote it was, quote, desperate to stop Trump. They didn't tell the guy who wrote it was being paid by the Clinton campaign to put it together. And they used that to get a warrant to spy on one of our fellow citizens. And you guys think that's no big deal. Bill Barr understands that's a big deal, and that's why John Durham is doing his investigation. And of course, you know who else thought it was a big deal? The Inspector General of the Justice Department, Michael Horowitz, who wrote a 400-page report talking about those 17 lies, talking about all the abuses that took place in the Comey, Biden, Obama Justice Department. But guess what? This committee, the Judiciary Committee, didn't even get a chance to ask questions of Mr. Horowitz about that report because the chairman won't bring him in to testify. I don't know if I've ever seen anything like that. 400-page report written by the Inspector General of the Justice Department, scathing report about the FISA court, and the chair of the Judiciary Committee, with the storied history this committee has in protecting people's liberties, won't even let him come in and testify. Well, here's what U.S. District Judge and FISA presiding judge Rosemary Collier said about the findings in Mr. Horowitz's report. Quote, the frequency with which representations made by FBI personnel turned out to be unsupported. Think about that. Representations made by FBI personnel turned out to be unsupported. You know what that is? That's a nice way of saying they lied, or contradicted by information in their possession and with which they withheld information detrimental to their case. Withheld information detrimental to their case is another way of saying they lied. Calls into question whether information contained in other FBI applications is reliable. You put that all in simple English, what Judge Collier was saying is, you guys lied to us so many darn times, how are we supposed to believe anything you bring in front of the court? That was all in that 400-page report from the Inspector General, but Chairman Nadler won't even let Inspector General Horowitz come in here and answer our questions and go into detail about that report. And yet today, the day we get the ruling from the Court of Appeals, the chairman says it's the Trump DOJ, it's the Barr DOJ that's political. Guess what else happened in the final days of the Obama administration? Guess what else happened? 38 different people unmasked Michael Flynn's name 49 times. 49 times. Clapper, Comey, Brennan, Biden unmasked Michael Flynn. 6 people at the Treasury Department. Holy cow. Everyone. This is between Election Day and Inauguration Day. And Bill Barr just simply wants to get to the bottom of all this, and somehow that's political, when in fact the politics was in the previous administration. He's trying to stop it so it doesn't. Here's what these people said. Here's how we know this was all a joke. Clapper. I never saw any direct evidence that the Trump campaign or someone was conspiring with the Russians. Jim Clapper said that, and yet we had a 2-year investigation by the Mueller team. Susan Rice, I don't recall intelligence that I would consider evidence. Ben Rhodes said the same. Sally Yates, I don't believe anybody had reached a conclusion yet as to whether Russians were conspiring with. They had nothing yet. They go through this entire investigation. Samantha Power, same thing. All these key people who were unmasking Michael Flynn's name all knew there was no predicate for the investigation, and it happened, and somehow the Barr Justice Department is political? Like I said, they're not political. They're just right, and we saw that with the decision today. Finally, let me just say this. I have never seen anything like, I've been saying this for I don't know how long, but it's the truth. I have never seen an agency where this happened. The top people, the very people Bill Barr, in that same testimony he gave where he talked about spying, he also said this. He said there was a failure of leadership at the upper echelon of the FBI in the previous administration. That may be the understatement of the year. Jim Comey fired, leaked memos in order to get the special counsel that put our country through what we went through the past few years. Andy McCabe, deputy director, fired, referred by that same IG for prosecution. Jim Baker, FBI counsel, investigated by the U.S. attorney in Connecticut, took information from the DNC lawyer. And of course, now famous Peter Strzok and Lisa Page, the individuals who ran the Clinton investigation, the mid-year exam, ran Crossfire Hurricane, Crossfire Razor, the Trump-Russia investigations. They were both kicked off Mueller's team. Peter Strzok was fired. We all know the bias they had against President Trump. We saw it in hundreds of text messages that are all now too familiar with. The politics was in the previous administration. Bill Barr is doing the Lord's work trying to clean it up so that it doesn't happen again. And we have said this before, and I'll say it in closing. Emmett Flood's statement a little over a year ago, where he said this: we would all do well to remember, if they can do it to a president, they can lie to a FISA court to get a warrant to go after a president, to go after a major party's political campaign. If they can do it to a president, imagine what they can do to you or I. Imagine what they can do to the folks we get the privilege of representing back home. That's why this is important. That's why the work Bill Barr is doing is important. You guys can continue to play your political games. Bill Barr is going to get to the truth. I yield back.
Mr. Chairman, I have parliamentary inquiry.
Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. Without objection, 3 letters from Bradley Weinsheimer, the Associate Deputy Attorney General, will be admitted into the record. I will now introduce today's
Mr. Chairman,
witnesses.
parliamentary
Point of
inquiry.
order. Gentleman will state his parliamentary inquiry.
What provision of the Democrats' new House rules allows for a duly subpoenaed witness to appear and provide testimony by video?
The rules so provide. I will now introduce today's...
Mr. Chairman, the copy of the subpoena that we have that was issued to Mr. Aaron Zelensky does not allow for that.
The gentleman has not stated...
The chair has not answered the inquiry.
Section 4F1
Appeal the
allows
ruling.
committees to issue subpoenas...
Appeal the ruling of the chair. We're not, the witnesses are not allowed to attend by video under the subpoena that the chairman issued.
Section 4F1 of the Rules of the House allows... The House Resolution 965 allows committees to issue subpoenas for return via remote participation.
The subpoena reads, you are hereby commanded to be and appear before the committee.
Gentleman will suspend. I will now introduce today's witnesses.
Appeal the ruling of the chair, Mr.
I
Chairman.
will now introduce today's
Mr. Chairman.
witnesses. Donald Iyer
Mr.
served
Chairman,
as
you have-
Deputy Attorney General under President George H.W. Bush. He joined the department as
Mr.
an
Chairman,
assistant
you
U.S.
cannot
attorney,
simply go over a
held a
point of order,
number
which
of
is
other
this to
positions.
repeal the ruling of the chair. And I'm speaking to you, gavel me down, but this is...
Rules
for
don't
18
matter
months.
in here, apparently.
18 months, he's appealed the ruling of the chair. At least honor the parliamentary procedures.
It is, there was a ruling. It was not...
Point of order, I challenge the subpoena being issued that he can appear remotely. I make a point of order.
That is not a cognizable point of
I
order.
challenge the ruling of the chair.
You cannot appeal a non...
Just denied my point of order. I challenge the ruling of the chair.
Donald Iyer served as Deputy Attorney General under
Here we go again. I appealed the ruling of the chair on a point of order. You cannot overlook that.
And Mr. Collins, you can't
no-
interrupt these proceedings, and the American people deserve to know the truth.
There was no
The
ruling.
This
rules
has
matter.
nothing to do with the truth. This has to do with the ruling of
There was
committee.
no ruling of the chair.
I made a point of order. You ruled. That's a ruling.
The point of order was not cognizable.
Then I appeal the ruling of the chair on not
There is
recognizing the point
not
of order.
ruling of the chair to appeal. Donald Iyer served as Deputy
Mr. Chairman,
Attorney
could I
General.
just-
Nothing changes around here.
This is too ironic.
Donald Iyer
Mr. Chairman, can I
served
just
as
raise-
Deputy Attorney General under President George H.W. Bush. He joined the department as an Assistant U.S. Attorney and held a number of other positions, including United States Attorney in the Eastern District of California and Principal Deputy Solicitor General under President Reagan. Previously, Mr. Iyer clerked for Justice William Rehnquist and Judge Malcolm Wilkie of the D.C. Circuit. After his career in public service, he was in private practice and has also taught extensively at law schools around the country. Mr. Iyer received his B.A. from Stanford University and his M.A. and J.D. from Harvard University. Aaron Zielinski is an Assistant U.S. Attorney for the District of Maryland. Previously, Mr. Zielinski served as a Special Assistant United States Attorney in the District of Columbia, as an Assistant Special Counsel in Special Counsel Robert Mueller's office, and a Special Assistant to the Legal Advisor in the State Department. Previously, Mr. Zielinski clerked for Justice Kennedy before his retirement from the Supreme Court, and for Justice John Paul Stevens after his retirement, as well as for Judge Thomas Griffith on the D.C. Circuit. Mr. Zielinski received his J.D. and B.A. from Yale University. I note for the record that pursuant to Section 4C6 of House Resolution 965, Mr. Zielinski's personal counsel is participating in this hearing on the WebEx software platform. John Elias is a trial attorney in the Antitrust Division of the Department of Justice. Since joining the department in 2006, he has served in a variety of roles, including acting chief of staff of the Antitrust Division. In 2015, following a detail to the White House's Presidential Personnel Office, he joined the Office of the Associate Attorney General, where he served for various periods as counsel, chief of staff, and deputy associate attorney general. Mr. Elias received his J.D. from Stanford Law School and his B.A. from Yale University. The Honorable Michael Mukasey served as the United States Attorney General from November 2007 to January 2009 under President George W. Bush. Prior to his service as Attorney General, he served as a judge in the Southern District of New York, becoming Chief Judge in 2000. Previously, he served as an Assistant United States Attorney for the Southern District of New York. He is currently in private practice. Judge Mukasey received his law degree from Yale University and his B.A. from Columbia College. We welcome all of our distinguished witnesses, and we thank them for their participation. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. And let me extend a special welcome to Judge Mukasey, whom I well remember from our...
Mr. Chairman, could we get a vocal from Mr. Zielinski? All we could see was his hand up.
Well remember from our dinners at...
I guess not.
Ramaz. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, for those witnesses testifying in person, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For Mr. Zielinski, there is a timer on your screen to help you keep track of time. Mr. Iyer, you may begin. Yeah, your mic.
Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of the committee. Thank you very much for inviting me to appear today. I was privileged to serve in the Department of Justice under 2 Republican and 1 Democratic president, and I am here because I believe that William Barr poses the greatest threat in my lifetime to our rule of law and to public trust in it. That is because he does not believe in its core principle, that no person is above the law. Instead, since taking office, he has worked to advance his lifelong conviction that the president should hold virtually autocratic powers. That includes immunity from nearly all checks and balances and being able to accord special treatment to himself and his friends. The system that Barr is working to tear down was put in place in the aftermath of the Watergate scandals, which involved extensive government corruption and caused a widespread loss of trust. After Nixon resigned, President Ford's Attorney General Edward Levy acted swiftly to restore trust by supporting reforms to prevent such abuses. These included statutes like FISA, the First Inspector General Act, expansion of FOIA, and the Whistleblower Protection Act. Levy knew that public trust ultimately depended on people believing that ours is a government of laws and not men, in which no person is above the law. That had special significance for the Department of Justice, whose work he saw imbued with a judicial nature. Its awesome powers demanded transparent and orderly decision-making processes subject to review at multiple levels and free from improper personal considerations or political interference. Levy emphasized the critical role of a dedicated professional staff who would bring zeal and determination and a great concern for fairness and impartiality. This vision has been an inspiration to generations of department lawyers. Bill Barr's service since last February has been a root and branch attack on Edward Levy's vision and reforms, indeed on the very idea that no person is above the law. Barr has sought to give the President nearly unlimited powers by negating or overriding many independent processes that operate as important checks on executive branch action. Here are some of the things that he has done. He has worked to defeat any meaningful oversight, either by Congress or by review in the courts, through litigation, legal opinions, and his own speeches. He has himself refused multiple times to show up in response to requests to appear before Congress. He has worked to undermine Congress's appropriation power by litigating the President's right to divert funds to pay for his border wall, which Congress refused repeatedly to fund. He has regularly undermined the authority of independent decision-making processes and career professionals whose disinterested integrity Levy saw as a key element justifying public trust. He has done this by his own statements, such as last March when he publicly whitewashed the Mueller report's extensive findings on obstruction of justice, and last December when he publicly contradicted key conclusions reached by Inspector General Horowitz in his FBI election interference probe. Both times, Barr's intervention vocally reaffirmed positions advanced regularly in presidential tweets. He has also done it by enlisting various political cronies to review and reverse decisions of experienced career attorneys, or by simply replacing them in handling matters of personal interest to the President. This is how he accomplished the reversals of long-held department positions in the cases of Trump associates Roger Stone and Michael Flynn, urging a much lighter sentence in one case and outright dismissal in the other. In a number of other matters, such as the intake of information from Rudy Giuliani and investigation of unmasking requests during the Obama administration, Barr has set aside certain subject matter to be handled by people in his political inner circle rather than by career officials who would deal with them in ordinary course. Finally, Barr has willingly supported removal of officials when their attention to duty proves politically inconvenient to the President. The treatment of U.S. Attorneys Jesse Liu here in the District of Columbia and of Jeffrey Berman in New York last Friday are two blatant examples. So is his standing by and voicing support as Trump, during April and May of this year, has removed 5 inspectors general who have long served as an important check on executive branch corruption. To an ever greater and quite shocking extent this spring, Barr has used the great powers of the Department of Justice to advance the President's narrow political interests and gravely undermine constitutional rights and the functioning of our democracy. Consider his apparent role in overseeing law enforcement action on June 1 to deny the right of peaceful protest in Lafayette Park, or the plainly frivolous motion filed last Friday to deny and denied one day later to enjoin publication of John Bolton's book for disclosing facts embarrassing to the President. Or worst of all, I think, are his flamboyant media discussions of the facts supposedly unearthed by the specially commissioned investigation he is personally conducting with the help of U.S. Attorney John Durham. Repeatedly, Barr has echoed the President's tweets and conclusively characterized the FBI investigation of Russian interference as an effort to spy on the Trump campaign and, as he put it, one of the greatest travesties in American history. And he has hinted repeatedly that indictments are likely. This conduct is a textbook violation of Justice Manual Rule 1-7.400, which bars public comment on criminal investigations before charges are filed. Here, though, the wrong is much worse, as Barr is using a criminal investigation to produce fodder for the president's campaign propaganda mill, which can have its effect even though it is false. This conduct in particular gives cause for great concern about what Barr may do next. Just another 30 seconds. In closing, it needs to be said that Bill Barr does regularly lie in ways that impact official action. Along with his continuing media project to make Americans believe that the FBI conspired against Donald Trump, his statements about the Mueller report, Jeffrey Berman's supposed resignation, and Barr's own role in the events in Lafayette Park come quickly to mind. So does his practice of regularly shrouding himself in the rhetoric and trappings of the rule of law, even as he desecrates and undermines the institutions that make it possible. But to me, Barr's crowning dishonesty
Gentleman's
is
time
the
has
portrait
expired.
of Edward Levy that a recent New York Times article showed hanging on the wall of his conference room, as though the current incumbent has
Regular
anything.
order, regular order, the witness will conclude. Regular order is right.
We're way beyond regular order.
The witness will continue.
Can I have one more sentence, Your
By
Honor?
all means.
Okay. But to me, Barr's crowning dishonesty is the portrait of Edward Levy that a
Mr.
recent
Chairman, I
New
would
York
ask that
Times-
that the sergeant at arms
The witness
be
will
called
conclude.
upon to stop the disruption of this meeting. I can't hear this witness. This is a very important witness.
Yeah, well, he's way beyond
And the
his
chair
time.
has
And if
the
there are no
authority-
rules about
the
when
chair
people
has
can
the
talk,
authority, does
there's
he
no
not?
rules about when you can make noise.
The gentleman makes a
Doesn't
good
the chair-
point, and the chair will enforce the 5-minute rule. Witness will proceed. will
Chair is
continue.
not enforcing the
Will con-
5-minute
The
rule.
witness will conclude.
Mr. Chairman, this is outrageous. Do you have no respect for the rules whatsoever?
The witness will conclude.
He's 2 minutes beyond concluding, and you don't let us have that kind of time. You gavel down immediately. You're being grossly unfair. This man had a
witness will
written
conclude.
statement, and he knew to cut it to 5 minutes. He couldn't do it. Either we have rules or we don't.
The gentleman will suspend. The witness will conclude.
Thank you.
Well, then
In
we can keep
closing, it
making
needs to be
noise.
said that Bill Barr does regularly lie in ways that impact official action.
Mr. Chairman, there's not order in the room. There's a banging.
No,
that's
there's certainly not.
disrespectful.
Mr. Chairman, would you have Gene Krupa removed?
The witness will conclude.
That's what you said a while ago, and he didn't conclude.
The gentleman will suspend. The witness will conclude.
So I guess the last thing I want to sum up with, I've said all the rest of this, but the last point I'd like to make is that I think his crowning dishonesty in the face of what he is doing to the Justice Department is the picture that I saw in the New York Times a few weeks ago, a portrait of Edward Levy on the wall of his conference room, as though the current incumbent has anything but disdain for the beliefs and achievements of his predecessor. Thank you, Your Honor.
Thank you.
Mr. Chairman, I have a parliamentary inquiry.
Gentleman will state his parliamentary inquiry.
Is it not appropriate for the chair to exercise discretion in extending the 5-minute rule as the chair sees fit?
It certainly is appropriate.
And is it authorized under the rules of this committee?
It certainly is authorized under the rules of this committee.
Well, then, cannot the chair call in the sergeant at arms to maintain order when a member of this panel is out of order and disrupts
We'll
the
move
meeting?
on to the next witness.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary inquiry, Mr. Chairman.
Mr. Elias.
Parliamentary point of order, Mr. Chairman.
There is no point of order.
How do you know I've not said one? Here we go
The
again.
gentleman is completely out of order, Mr.
The
Chairman.
gentleman will state his point of order.
Point of order is according to the House rules, a House chairman cannot capriciously determine the 5-minute rule at the whim of what he wants. It has to be fairly and impartially applied. That is the spirit of the House rules, and that is not what has happened.
apply it fairly?
We are applying the 5-minute rule as provided by the House rules.
So you're ruling on my point of order?
The gentleman has not stated the point of order.
I did say the point of order. I stated the point of order is the rules are being violated by a capricious chairman who is not following the rules of the House by arbitrarily deciding when the 5-minute rule will be applied and when it will not be applied.
You have not stated a cognizable point of order. The chairman has discretion.
Mr. Chairman, you've not stated a recognizable way of running a committee in 18 months. So, I mean,
Gentlemen,
let's determine
the
it.
gentleman will suspend. The gentleman has not stated a cognizable point of order. Mr. Elias.
I did earlier, and you blow over it.
The gentleman will suspend. Mr. Elias.
Good afternoon, Mr. Chairman, Ranking Member Jordan, and members of the committee. My name is John Elias, and I am a career attorney with the Department of Justice. I joined the department in 2006, and over the past 14 years, I have served under 6 attorneys general and 3 presidents. I've spent my entire legal career at the department. Although I am a current department attorney, my testimony is personal and does not represent the views of the department. Throughout my career in federal service, I have been taught to do the right thing for the right reasons in the right way. That is why, earlier this year, I asked the DOJ Inspector General to examine whether multiple antitrust investigations launched under Attorney General Barr were abuses of authority or other misconduct. The first matter that I referred to the IG concerned 10 investigations that the Antitrust Division launched into merger activity in the marijuana or cannabis industry. These mergers were not even close to meeting established criteria for these kinds of investigations. And yet, these cannabis investigations accounted for a full 29% of the division's full review investigations last fiscal year. For context, these kinds of investigations are rare. On average, only 1% to 2% of the thousands of transactions that come before the division each year get a full review. In the first of the cannabis investigations, the merger of MedMen and PharmaCann, career attorneys examined the proposed deal and determined that the transaction called for no further antitrust review. Staff reached this conclusion using the criteria under the horizontal merger guidelines that have guided the division for decades. However, on March 5th, 2019, Attorney General Barr called the Antitrust Division leadership to his office and ordered the division to proceed with a full investigation. The division staff complied, issuing burdensome 15-page subpoenas that compelled production of 1.3 million documents from 40 personnel, all at great expense to the companies. Although the division ultimately found no evidence of antitrust problems, the companies abandoned the merger, citing delays in regulatory approval. The Antitrust Division went on to conduct similar investigations of 9 other mergers in the cannabis industry. Division staff continued to document at the outset the lack of any bona fide antitrust issues. In some cases, the companies operated in completely different geographies and did not compete at all. Nonetheless, the division continued to issue subpoenas and compel productions of millions of documents from these businesses. At one point, the office handling agriculture became so overwhelmed with cannabis investigations that it had to pull in attorneys from the telecommunications, media, and technology offices. In response to staff concerns about these investigations, the head of the Antitrust Division, Assistant Attorney General Del Rahim, acknowledged at an all-staff meeting that the cannabis industry is, quote, unpopular on the 5th floor, unquote, referring to AG Barr's offices at DOJ headquarters. But personal dislike of an industry is not a valid basis upon which to ground an antitrust investigation. The next investigation that I reported to the IG concerns an arrangement announced in July 2019 between California and 4 automakers to limit fuel emissions. After news reports indicating that the president was enraged by the arrangement and wanted to retaliate, President Trump criticized the deal on Twitter. The day after the tweets, Antitrust Division political leadership instructed staff to initiate an investigation that very day. Ordinarily, decisions of import, here an investigation of a $630 billion automobile market, would take time and care to evaluate, especially when the action would face defenses. In the hurried investigation paperwork, staff acknowledged that it had only partially examined public information. Members of the committee, I have undertaken whistleblower activity and am here today because I recognize the imperative for law enforcers to operate even-handedly and in good faith. I reported these matters to the IG because they were evidence that our nation's antitrust laws were being misused. These laws have protected American markets and consumers for more than a century. The hundreds of career staff at the Antitrust Division take this mission seriously and expect DOJ's political leadership to as well. I thank you for examining these issues and will be happy to answer your questions.
Thank you. Attorney General Mukasey.
Thank you. Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of this committee. Thank you for inviting me to testify at this hearing. The topic of today's hearing, claims of politicization of the Justice Department, is serious and important because the fundamental duty of the department is to pursue equal justice under the law, and we can and should expect no less. As you may know, I was privileged to lead the men and women of the Justice Department during the George W. Bush administration. Before that, I served for over 19 years as a district judge in the Southern District of New York, and that's the perspective that I bring to the testimony today. The department needs capable, experienced, and even-handed leadership. Its components and programs have reach across the country and across the world. It handles matters as diverse as antitrust and anti-terrorism. It takes an experienced lawyer and leader to manage such a department effectively, and I believe without reservation that William Barr is that kind of a leader and that this country is fortunate that he leads one of the most important government departments. I do not have firsthand involvement in the particular matters to be discussed today, but based on my own experience, I can assure you that those are not issues of first impression for the department or for the federal courts. The Justice Department is not politicized because senior officials disagreed with the sentencing recommendation for Mr. Stone. Trial lawyers in the department are zealous advocates. That's their job. But zeal does not confer perfection or assure justice. My views on this case are no secret. I set them out in a piece written with Attorney General Meese in the Wall Street Journal, where we pointed out that the sentencing guidelines, which were adopted in 1987, initially as presumptively binding on the courts, have been strictly advisory since 2005 under Supreme Court law. Both as a judge and as Attorney General, I have declined to follow sentencing recommendations from trial lawyers. As Attorney General Meese and I wrote, prosecutors are supposed to seek justice, not to play the sentencing guidelines like some sort of pinball machine to see how many times they can ring the bell, or to try to pressure a judge to impose a harsh sentence, and also thereby cast doubt on the competence of the government by reading guidelines in a didactic and hyper-technical way without applying the one element that must be present when you read any law, whether statute or guidelines, and that is common sense. In a highly publicized and politically fraught case, it was not only proper, but also advisable for the Attorney General to assure that the government's sentencing recommendations not promote that unworthy end. The decision to lower the recommendation was reached by others in the department as well, including career lawyers, one of whom signed the lower recommendation. Attorney General Barr said publicly that he believed Mr. Stone's prosecution was warranted, and that with his conviction that a jail sentence was warranted, and that the jail sentence imposed by the judge was appropriate. I believe the trial judge agreed with the initial sentence, that the initial sentencing recommendation was overly harsh, as her sentence reflects. The Justice Department is not politicized because prosecutors dropped charges against General Flynn. In fact, as you heard this morning, the D.C. Circuit issued a writ of mandamus directing that prosecution stop. As I understand it, the former FBI director talked publicly about having sent agents to interview General Flynn without following applicable protocols. And not using proper protocols wasn't simply a delicate problem of etiquette, like using the fish fork instead of the salad fork. It followed the deputy director's assurance to General Flynn that he need not have a lawyer present, and having agents base their investigation on a potential violation of a law, the Logan Act, that has never been prosecuted successfully since its adoption in the 18th century. It's probably unconstitutional, and that no rational person would apply to a potential national security advisor in any event. And this morning we saw documents showing that that theory was discussed on January 4, 2017, at a meeting in the Oval Office, which is to say the interview was a pretext for getting General Flynn, as one senior FBI official put it, to either lie or admit to something that could have him fired. The duty of the department is to do justice, and that does not end after a guilty plea, particularly when that plea is procured with a threat to prosecute the defendant's son, that is concealed from the court and the probation department so that it would not have to be disclosed to future defendants against whom General Flynn might testify. That is a particularly gag-inducing feature of this episode to me as a former district judge, that was being kept from the court. It is not unheard of for a prosecution to be dropped, even after a guilty plea, following the disclosure of new information that shows continued prosecution would be a miscarriage of justice. There seems to be a tendency these days to read ulterior motives into every action of Attorney General Barr. As Attorney General Meese and I noted in our article, it's helpful to consider a few data points from Attorney General Barr's tenure. First, despite his own skepticism about aspects of Special Counsel Robert Mueller's investigation, he allowed that investigation to run its course. Second, he supported the decision not to prosecute former Deputy FBI Director Andrew McCabe, a frequent critic of the president, despite evidence that not only did McCabe lie when he denied leaking information, but that he also berated others for the leaks so as to deflect suspicion from himself. He also
Mr. Chairman, point of order. We are again being disturbed by tapping as the chair exercises his discretion in letting the witness testify beyond the 5-minute rule, and I'd like for that tapping to stop, and if it doesn't, I'd like for the
You want somebody removed because they want the rules enforced?
Order.
That's amazing.
Mr. Gomer, you're not presiding over this hearing. Mr.
gentleman is
Nadler
correct.
is.
The members will show
Some of us
courtesy
would
to
like the rules enforced.
The members will show courtesy to the witnesses, Mr. Gomert. The witness may proceed.
Thank you. So far as the claim that William Barr's service is somehow a desecration of Edward Levy's service, I should point out that Edward Levy's portrait hangs where it hung when I was Attorney General, and that Edward Levy's grandson serves proudly as Attorney General Barr's Chief of Staff. So that attack is totally unjustified. Now, I've come to know Attorney General Barr over the years. I've had many discussions with him about the law and about public policy issues. And based on that, I have no doubt that the welfare of this country, upheld through the even-handed application of law so as to achieve justice, is what motivates him and motivates his decisions, and that's all that motivates his decisions. I think we're fortunate to have a person of his temperament, talents, and convictions in office during this difficult time in history, and I thank you very much, and thank you for your indulgence, Mr. Chairman.
Thank you. We'll now proceed under the 5-minute rule with questions. Before I recognize myself... Oh, didn't we? Nope, he's on the... Oh, I am sorry. We have Mr. Zielinski on video, and I didn't realize. Mr. Zielinski will now testify.
Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of the committee. In response to your subpoena, I'm here today to testify about United States versus Roger Stone. I apologize for not appearing before you in person, and I thank the committee for allowing me to appear remotely today. For family reasons, I should not risk infection. As the chairman mentioned, I'm privileged to serve as an assistant United States attorney, a nonpartisan career prosecutor. Our job is to see that justice is done in every case, without fear or favor, without party or politics. It's unusual for a prosecutor like myself to testify about a criminal case, and as outlined further in my written remarks, there may be reasons why my testimony will therefore be limited in some respects. The Department of Justice has cleared me today to discuss matters related to the Roger Stone sentencing. Let me now turn to the Stone case. The first thing that every AUSA learns is that we treat every defendant equally and fairly. In the United States of America, we do not prosecute people based on politics, and we don't cut them a break based on politics either. But that wasn't what happened here. Roger Stone was treated differently because of politics. At the time of these events, February of 2020, I was a career assistant United States attorney, as I am proud to be now. I was not privy to discussions with political leadership at the Department of Justice. My understanding of what happened is based on two things: what I saw and what I heard. What I saw was that Roger Stone was being treated differently from every other defendant. He received breaks that are, in my experience, unheard of, and all the more so for a defendant in his circumstances, a defendant who lied to Congress, who remained unrepentant, and who made threats against a judge and a witness in his case. And what I heard repeatedly was that this leniency was happening because of Stone's relationship to the president, that the acting U.S. attorney for the District of Columbia was receiving heavy pressure from the highest levels of the Department of Justice, and that his instructions to us were based on political considerations. And I was told that the acting U.S. Attorney was giving Stone a break because he was afraid of the President of the United States. I believe that was wrong, and together with my fellow line prosecutors, I immediately and repeatedly said so. Unfortunately, our objections were not heeded. First, we were pressured to reduce the initial sentencing guidelines calculation for Mr. Stone without any clear legal rationale for doing so. When we refused to go along, we were instructed instead to disregard the guidelines entirely and to recommend an unspecified lower sentence for Mr. Stone. I was told that to the best of anyone's recollection, such a recommendation has never been made by the Fraud and Public Corruption section of the United States Attorney's Office. When we again refused, we were told that we could be fired if we didn't go along. I notified the office that I intended to withdraw from the case rather than file a memo that was the result of wrongful political pressure. And while all this was happening, I was repeatedly told the department's actions were not based on the law or the facts, but rather on political considerations, Mr. Stone's political relationships, and that the acting U.S. Attorney was afraid of the President. Shortly after I informed the office of my intent to withdraw, office leadership changed its position and allowed us to file a sentencing memorandum properly calculating the guidelines and seeking a guideline sentence. We filed the memo and heard nothing further that evening. But at 2:48 a.m. that morning, the President tweeted that the sentencing memo was horrible and very unfair and cannot allow this miscarriage of justice. Later that day, we learned the department was going to issue a new sentencing memorandum, mischaracterizing the application of the sentencing guidelines and asking for an open-ended downward departure for Mr. Stone. We were not allowed to see the new proposed memo. We weren't even told who was writing it. At this point, I made the difficult choice to resign from the case and my assignment in the U.S. Attorney's Office in D.C. I resigned because following orders would have violated the oath I swore when I took my job. To be clear, my concern is not with the sentence Mr. Stone received. I'm not here to criticize Jackson's sentence or her reasoning. My concern is about process. The Department of Justice treated Roger Stone differently from everyone else, and I was told that the department cut Roger Stone a break because of his relationship to the President. I take no satisfaction in publicly criticizing the actions of the Department of Justice, where I have spent most of my legal career. I have always been, and I remain proud to be, an Assistant United States Attorney. It pains me to describe these events, but as Judge Jackson said in this case, truth still matters, and so I'm here today to tell you the truth. I would be pleased to answer your questions.
Thank you very much. We will now proceed under the 5-minute rule with questions. Before I recognize myself for questioning, without objection, correspondence between our witnesses, Mr. Elias and Mr. Zielinski, and the Department of Justice in advance of their testimony today will be entered into the record. These letters establish the parameters in which they are allowed to testify. I will now recognize myself for 5 minutes. Mr. Zielinski, you recommended a sentence of 7 to 9 years in prison for Roger Stone's felony crimes. Was your recommendation based on department guidelines?
Yes, it was.
And based on your 14 years at the department, did you believe that recommendation was warranted?
I want to correct you, Chairman. I have been at the department for just about, it'll be 6 years this November. But based on my experience, I did believe that the recommendation was warranted, yes.
But leadership at the department wanted a lower sentence. When you asked the department why they wanted a below-guideline sentence for Mr. Stone, you were told it was, quote, political and because the U.S. Attorney was afraid of the President. Is that correct?
That's correct.
What did you understand that to mean?
I understood, as described in my written statement, to mean that political considerations were weighing in the U.S. Attorney's decision, and that the concern about the President was driving his decision-making process.
And what were you told could happen to you if you refused to go along with this lower recommendation?
We were told that we could be fired.
Now, you've described clearly that the department treated Roger Stone differently than any other defendant because of his relationship to President Trump. Is this against department policy?
It is.
And is it wrong?
It is.
Is it unethical?
It is.
You wrote in your written testimony that it pains you to describe these events. Can you explain why it pains you?
Mr. Chairman, I took an oath when I took this job, as did all of my colleagues who are assistant United States attorneys across the country. We are immensely proud of what we do. We are proud to serve in the Department of Justice, and we are proud that we prosecute without fear or favor. To describe an abdication of responsibility like this, and this sort of contradiction of all the reasons that we have taken these jobs is deeply painful to me.
Thank you. Mr. Elias, we just heard from Mr. Zelensky how the department violated its own policies just to appease the president's whims. In your testimony, you describe a similar pattern. Am I correct that the department also pursued antitrust investigations against the advice of career attorneys to satisfy the political and personal whims of President Trump and senior leadership at DOJ?
Yes, you are correct.
And do you believe these investigations are in the best interest of the American people?
I do not, no.
And in your opinion, should the department have prioritized investigations that benefited the American people instead of pursuing the Attorney General and President's political vendettas?
I think the department should be using its resources in a way that fulfills its mission, yes.
Mr. Iyer, I'd like to turn to you. You have decades of experience in public service at the highest levels of the Department of Justice. These witnesses confirm that the Attorney General is weaponizing government resources, taxpayer dollars, to pursue investigations that do not in any way benefit Americans, but instead advance the President's personal and political agenda. Briefly, what is the impact on our justice system if Barr is allowed to get away with this?
Well, let me just correct one thing. I don't really have decades. I really had a little over 1 decade, but nonetheless, to answer your question, I think the problem is that there's a finite number of resources to be spent to advance a whole lot of areas of our justice system. And so you're throwing money away, that's the first thing. But the more important thing is that by channeling enforcement efforts into inappropriate targets for the purpose, in some cases, of harassing people, which I think is often what we're dealing with, and also for channeling resources and spending time trying to give a special deal to other people, you're not only wasting money, but you're totally undermining public trust in the system. You're creating a situation. I think we're on the way to something far worse than Watergate, where you had a problem of public distrust because it's becoming very transparent that many things are being done essentially for reasons that are completely unrelated to the merits of the case.
Mr. Zelensky, you testified that you came forward because telling the truth still matters. I too believe the truth still matters, and we will not let this conduct stand. Attorney General Barr will be held accountable. And I recognize the gentleman from Ohio.
Thank you, Mr. Chairman. Today's hearing is yet another attempt by the majority to smear this president and his administration. My Democratic colleagues were shocked and deeply offended that he won the presidency in the first place. They're still grieving that they failed to remove him from office through their phony impeachment debacle. And now they're targeting administration officials, in this case, Attorney General Barr, for merely acting within the scope of their duties. Where was the outrage when the Obama-Biden Justice Department investigated journalists, or when they retaliated against whistleblowers, or when they surveilled the Trump campaign? It's hypocrisy, and most people are going to see right through it. It just shows that the majority will stop at nothing in attempting to distract and harass this president and his administration. Their efforts are particularly disturbing at a time when a global pandemic has negatively impacted us all, and the country has been rocked by racial strife and civil unrest. There are other more important things we ought to be focusing our time and attention on rather than this distraction. Despite an exemplary record and career, Democrats are now going after Attorney General Barr. Why? Because he's cleaning up the mess of the previous administration and restoring integrity and honor to the DOJ and the FBI. Now, speaking about messes, from the previous administration, Hillary's funding of the Steele dossier and the FISA scandal led to the Mueller investigation and the waste of a whole lot of our time and taxpayer dollars. Now, Mr. Zelensky, you were part of that Mueller team, weren't you?
I was.
And that supposedly unbiased team of 17 attorneys consisted of 13 Democrats. That doesn't sound very unbiased to me. Does it to you?
I would disagree with the premise of your question. We are, as I said, career professionals. Prosecutors do our job, and we do it regardless of party or politics.
But it was
And we did
13
then, and we do
Democrats.
it now.
13 Democrats out of 17.
There's been public reporting to that effect.
All right, thank you. Former Deputy Attorney General Rod Rosenstein, your boss, I believe, testified before the Senate recently that he wished Mueller had chosen a, quote, more politically diverse group. Don't you think he has a point?
I don't think it would be appropriate to choose any prosecutor based on their politics, and that is not what the special counsel did in that circumstance. In fact, if anything, if the special counsel had tried to weigh the politics of the prosecutors when he was choosing them, that would have been far more deeply problematic than what he did, which is
I guess it
hiring
was just
professionals to do their job.
Coincidental 13 out of 17. Something else I'd like to point out that I think clearly shows that there was indeed bias on the Mueller team was that as a group, they'd given $3,000 to Republican candidates in the past, but over $60,000, $62,000 to be exact, to Democrats, a 20-to-1 bias in one direction. Mr. Mukasey, let me turn to you if I can at this time. Do you believe that the Department of Justice under Attorney General Barr has become politicized, as my colleagues on the other side are alleging?
As I said, I do not.
Would you agree that Attorney General Barr has worked to root out politics, in fact, and bring transparency back to the department?
I think he has bent every effort to try to run the department the way it should be run and to conduct investigations on the merits.
Do you believe that Attorney General Barr makes decisions based upon political calculations or upon the relevant facts and law?
I believe he makes decisions based on the relevant facts and the law, and that if he made decisions based on political calculations, he would not have made the decisions that I alluded to in the last part of my remarks.
Absolutely. I completely agree with you. I'm almost out of time, so let me conclude with this. Mr. Chairman, this hearing is just another sad attempt by you and the majority to attack this administration, specifically the Attorney General, unfairly. And it's a shame. Because there's so much other important work that we should be engaged in order to unite this nation, not to further tear us apart. And with that, I yield back the balance of the time.
The gentleman yields back. The gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman. Given the appearance of political influence exhibited by this administration and the AG, and based on the testimonies presented to us, I'm concerned about the integrity of our elections. In February, the Attorney General issued a memo outlining restrictions and policies for campaign-related investigations. I'd like to make a copy of that memo available in the record. Now, in part, the memo requires that no investigation may be opened or initiated of a declared candidate for president or vice president, et cetera, absent written approval of the Attorney General. This is a departure from previous campaign investigation protocol. And having heard from witnesses today about the significant political influence affecting the Department of Justice, this at the very least raises the specter that decisions to investigate presidential campaigns could be politically motivated. Mr. Iyer, does the appearance of political influence over investigations into presidential campaigns raised by this memo concern you?
It does, and it's one of a number of things that does. Obviously, the election is upcoming, and it's a hugely important phase of our national life. And so the idea that we're not going to be handling possible investigations relating to the election, we're not going to be handling them in the ordinary course by even-handed professionals who are trained to do it, but we're going to have them handled in some special way, which I don't think we really know quite what it is. We know that it's a cadre of people that, that Mr. Barr has sort of set aside and said they'll handle this. This is only one of a number of areas where he has done this, and we know of some. I'm afraid there are others we don't, where whenever there's something sensitive, it essentially gets turned over to somebody that he can trust as opposed to someone who's a professional, trained, and even-handed in their handling of it.
Thank you very much. You know, I want to talk about concerns that the Attorney General is abusing power in a way that is quite real to Californians. As we know, the Supreme Court has held that due to their stake in protecting their quasi-sovereign interests, states have the authority to set regulations governing greenhouse gases. That's the Massachusetts versus EPA case from 2007. Now, California has applied for and received more than 100 clean air waivers over the past 50 years. None have been revoked. And as a result, the average car sold nationwide is more than 99% cleaner than a car from the 1970s. Now, as we know, the Trump administration has attempted to curtail Californians' action, and following that, car makers in California worked together to come up with emissions that would work for California. This is important. This isn't just arcane stuff. I mean, in the Central Valley of California, we have the highest asthma rate among children in the United States, and a lot of that is because of emissions on I-5 and I-90 and Highway 99. So when I saw this, the antitrust announcement, I thought he's just trying to scare these automakers, to let them know that they're going to have to spend a lot of money if they deal with California as the law permits them to do. Mr. Elias, the investigation initiated, was there any legitimate antitrust concern, or was it simply because an effort by the administration to muscle the auto companies into not dealing with the state of California?
So as I pointed out, the coincidence in time with the opening of the investigation was the day after the Trump tweets. I think staff had looked through some public resources, public laws, to see whether it might be permissible or not. And that kind of thing we do all the time and don't proceed to a formal, full investigation. So to answer your question, no, I don't believe there was a proper basis to actually go forward with a formal investigation.
Well, it looked to me that the department announced these investigations in really a bad faith manner after the president publicly threatened these companies for disagreeing with his own policies. This matters. It matters not in an arcane way or in an academic way. It matters to the lungs of the children of the state of California. And I think it's a direct example of how misconduct and political corruption in the Department of Justice has a direct adverse impact on the people of America, and most specifically, in this case, the people of California. I just like to note that I too was around during the Watergate matter, and I see some parallels, but actually this is worse than Watergate, worse than Nixon. I see my time is up, Mr. Chairman, so I yield back.
The gentlelady yields back. Mr. Gohmert.
This is incredible. Mr. Ayer, you called Jeff Jensen, a 20-year career prosecutor, a political crony. By the way, you care to say into the microphone what you mouthed at me earlier when you'd gone over 2 minutes past your time?
I didn't mouth anything at you, Congressman.
Well, you just showed your lack of credibility, both with Thornburg and people that have followed, has a real basis in fact. And in fact, rarely have we had anybody with the chip you have on your shoulder come before us. Thornburg said he believed that you were really never around. He said, Bill Barr was and I'm quoting, the first deputy I had, and that came when I was 2 years into the job. Anyway, I understand you got fired by Thornburg. In fact, he said, Ayer proved, this is in his book, Ayer proved to have exaggerated notions of his responsibility to resent my confidence in Ross Runkle and Murray Dickman. Soon developing a serious chip on his shoulder, he began taking actions independent of or in conflict with my wishes. Once he sent a letter to Boyd and Gray containing recommendations for corporate sentencing guidelines I'd not even reviewed. Ayer's resignation was announced on May 11th. Bill Barr succeeded him and proved to be the deputy I had needed from the beginning. So I can understand why you'd be resentful 30 years later, but at some point, hopefully, Mr. Ayers will get over his chip. And the fact that Mr. Zelensky, I was going to ask him questions, but, and I understand family matters, and by the way, I'm grateful to my wife for sticking with me for 42 years today, and there are family matters. Yeah, she's a lot more fair than we're getting around here, but so 42 years. Thank you, Kathy. Some of us have family matters too that are very pressing, but this is very pressing too. And I won't try to compare those. But Mr. Barr has come and testified, and he's coming again soon. So statements that he wouldn't come here, they're just not true. And you know what? I've not heard anybody, any of these three Democrat witnesses, express any concern for the Justice Department under President Obama going after local law enforcement. Why? Because in the opinion of the Justice Department, they had violated people's civil rights. And A.G. Barr had that same concern, that people's civil rights were being violated by governors or local authorities. And if he had no right to say anything, then the Justice Department under Obama had no right to pursue local law enforcement either. But I guess it just, again, testifies to the credibility or the lack thereof of the people that have been brought before us. It is absolutely incredible that people could come in here and after the Justice Department, the FBI, including the FBI, Intel, top people, even DOD was paying Stephen Halper. All these people were involved in trying to prevent a Republican from becoming president, and these three witnesses don't have any problem whatsoever with that. History will not judge you kindly in the days ahead, whether we get to continue this little experiment in self-government or not, because you have been an accomplice after the fact to what has occurred in the Justice Department, and you are so biased you cannot even see it. So I don't have a lot of questions for people who don't have credibility, have chips on their shoulders. Mr. Elias, for heaven's sake, you come in here with your complaints. It's a shame we don't have a serious hearing. It's just a sideshow, and it ought to be called for what it is, and that's why I am. And if we're concerned about justice, we need to get after the people that created the injustice through the last administration. And I yield back. And Hank, I don't have any problem with you doing that. If I see my
The gentleman yields back. The gentlelady from Texas.
Mr. Chairman, I know that we are not here to discuss personnel matters of the witnesses. Let me acknowledge General, for your presence here today. Mukasey, we have certainly worked together in the past. Let me acknowledge our three witnesses, of whom each and every one of you are patriots, and I thank you for your service. I'm reminded of the time of the Department of Justice when those of us in the South, during the midst of the civil rights movement, looked to the DOJ for the relief of then the Assistant Attorney General for Civil Rights. Honest, straightforward, and dealing with not the crisis, but the bloodshed of the South in the midst of fighting for freedom. They were a hand that we held on to. I am disappointed that we now face the circumstances of a drunken party gone wild. Sadly, the Department of Justice has gone wild. So I think it is important that we highlight and begin to move on correcting the wildness, the out of controlness, and begin to focus on standing up a Justice Department that works for the American people. We heard today from all of you about the effects of the President's politicization of his Justice Department for his own ends. My colleagues on the other side of the aisle would like to suggest that this is not true. They want to cover their ears to this injustice. So I'd ask them what Jonathan Kravis, a career prosecutor with a decade of experience, similar to some of you here today, asked in his recent op-ed, quote, "If the department truly acted because of good faith, commitments to legal positions, then where is the evidence of those commitments in other cases that do not involve friends of the president? Where are the narcotics cases in which the department has filed a sentencing memorandum overruling career prosecutors? Where are the other U.S. attorneys who wouldn't go quietly into the night?" And as Mr. Kravis wrote, there are none. All of the cases are political cases, friends of the president. Is that because the only case in the United States that warranted intervention by department leadership happened to involve friends of the president, or of course not? Is that because attorney generals regularly lie to the American people about U.S. attorney resigning, when in reality he is being pushed out for prosecuting the president's inner circle? Of course not. Remember the Attorney General Barr, it was the president that fired him. Remember the president saying, "I had nothing to do with it, I didn't know anything about it." What the Department of Justice is doing is an unprecedented erosion of our constitutional system. It has gone wild. My colleagues on the other side of the aisle have been refused to acknowledge the truth for a while. When asked about Lafayette Square, they said they didn't see it firsthand. It is never acceptable to turn a blind eye to injustice, and thousands of former officials are now coming out to speak truth to power. There are literally thousands of individuals across Republican, Democratic administrations. Over 2,000 who worked in the Department of Justice signed a letter. So it is a grave threat to fair administration in this nation. We are all equal before the law. A person should not be given special treatment in a criminal prosecution. Thousands of department officials wrote again after the Flynn prosecution expressing the same sentiment, and yesterday members of George Washington Law School faculty did the same. Over 1,000 former DOJ talked about the rule of law. I believe it is a clear and present danger, and he must be held accountable, the Attorney General, who, yes, has been invited to this committee, but has refused over and over again. Mr. Iyer, you have served in multiple administrations in both parties. Are these thousands of people right? Is Barr's current and present danger to our constitutional order of the rule of law, constitutional order, rule of law, and even-handed administration of justice? Is Attorney General Barr a current and present danger? Mr. Ayers.
Yes, Congressman Jackson Lee, I think he is, and that was the theme of what I tried to say before. And I think essentially it's for two reasons. One is that he has a personal belief that the president should be above the law, and he has worked very hard to achieve that by negating the checks and balances in a variety of ways, by making the president not accountable, stonewalling the Congress, stonewalling the Southern District of New York, the District Attorney's Office trying to do a criminal investigation, so preventing information from coming out, and otherwise essentially putting the president beyond the law. The second thing he's doing, and this has accelerated this spring, is getting involved in a very political way, essentially in using the Justice Department to support the president's campaign. And comments he's made about opening up the country, that the activities in Lafayette Square. The most serious problem here that I'm concerned about is his accelerating recitation of this narrative about, I don't know what you call it, Obamagate or deep state conspiracy or whatever it is. The thing that we were hearing from Ranking Member Jordan earlier, he is using the fact that he has his own investigation going on as a basis for supposed facts to assert that these things are true. Number one, I don't believe they're true, but more importantly, that is a totally improper misuse of the Department of Justice. Even if those facts were true, it would be a violation of the Justice Department rules to be reporting to the public on things that he's supposedly finding in that investigation. And if you look at my written submitted testimony, you will see just a very concise chronicle of the number of times he has gone on television to make, and on the radio, to make these assertions in detail about these things that are going on. In fact, one of the ones that I had to chuckle about was on Sunday with Maria Bartiromo. He actually said that he was surprised that the public doesn't seem to be paying attention to the things that he's been saying about these outrageous things that have been uncovered. He doesn't understand why people aren't paying enough attention to his reports on the Durham investigation. Well, that is gross violation of the Justice Department's policies, even if the facts were true, which I frankly think they clearly are not. So we have a real problem here, and the drumbeat of his misbehavior is accelerating as we get closer to the election. I don't know what's next, but I'm scared to think about what it might be.
The time of the gentlelady has expired.
Mr. Chairman, I'd like to ask unanimous consent to submit into the record DOJ alum statement on Roger Stone, DOJ alum statement regarding the sentencing of Roger Stone, and statement on Mr. Flynn, and DOJ alum statement to Michael Horowitz, the Inspector General. I ask unanimous consent to place these in the record at this time.
Without objection, as I notified members during the markup on June 17th, I view the wearing of face masks as a safety issue and therefore as an important matter of order and decorum. Because I am responsible for preserving order and decorum in this committee, I am requiring members and staff attending this hearing to wear face masks. I came to this decision after the Office of the Attending Physician released new guidance requiring masks in committee hearings. The Chair's authority to enforce the preservation of order and decorum during committee proceedings derives from the Speaker's enforcement authority under Clause 2 of Rule 1 of the House. The Chair would greatly prefer that all present simply uphold the decorum of the committee by complying with these reasonable safety standards. Failing that, any member who fails to wear a mask will not be recognized. I now recognize the Mr. Collins.
Thank you, Mr. Chairman. I appreciate that. And I would like to make a couple of statements. Number one, there may be discretion for the chair in opening statements, and you may enjoy hearing Ms. Harris talk, but under Rule 11, you do not have discretion under the 5-minute questioning rule to continue that. It is interesting, though, the ways we talked about political consideration of prosecutors today. In fact, I have a really big problem going on right now in Fulton County, Georgia, where a prosecutor, it appears, has put political motivations in a re-election bid at the heart of going after the Atlanta Police Department. And just as was said earlier by a gentlelady from Texas, it's never acceptable to turn a blind eye to unfairness, and this needs to stop. Mr. Howard does need to remove himself, and the investigation, which has never been done and finished, needs to continue so that the right can be done for all parties, as we have been speaking about prosecutorial ethics today. No, I will not. You're considering, Mr. Elias, you consider yourself to be non-political career staff. That was your statement, correct?
When I go into the Justice Department every day, as a career employee, I leave my politics at home, yes.
Okay. And that was the same as Mrs. Linsky, Mr. Strutt, Ms. Page, others have done that. Let me ask you a question. As a career staff, being non-political, did you ever attempt to get detailed to this committee's majority staff?
like
Yes or no?
people over time have explored various career options.
Did you, within the last, under this majority, ask to be detailed to this majority staff?
I had a very preliminary conversation with.
So you did have a conversation?
Yep.
Was it to work on antitrust policy?
It was, yes.
Okay, and as we have all sworn under oath here, in fact, did you not ask to be detailed to the committee's work on oversight during impeachment? Is that not correct? Refresh your memory.
I may have also asked for oversight at one point with the blessing of Assistant Attorney.
Okay, so you asked to come to this committee as a career staffer, non-political career staffer. You were asking to be detailed to this committee to work on impeachment. You wanted to come work for the majority during the impeachment of Donald Trump. Is that not correct? If not, I understand how that answer would be troubling. So if you want to just stop right there, you've answered.
I actually think that I think it was a year prior. I honestly think it was.
But the detail to this majority, we were the majority beforehand. This was to the majority.
It was early 2019.
Okay, that's the majority of this staff here, and we were starting every investigation on demand at that point. In fact, they hired very good attorneys out in New York, become friends with them. But you asked to come to this committee. So, Lynn, a little bit of the career staff, let's just leave it there. Let's go to your actual testimony today.
Okay.
In your written testimony, you contended that mergers with cannabis industries were, quote, unlikely to raise significant competitive concerns. You further stated that a few of the documents produced in response to the subpoenas were ever reviewed by antitrust division staff. You essentially said that the second requests were made for purposes of burdening these companies. So you filed, as you cited earlier, a DOJ complaint about this with the Inspector General. Is that correct, yes or no?
Yes.
Okay. And the Inspector General handed the complaint over to the Office of Professional Responsibility for the investigation, correct?
No.
Excuse me?
The Office of Special Counsel handed it to the Office of Professional Responsibility.
So, but it was handed over and investigated. Is that not correct?
That's correct.
Okay. So, as you're reading, and that is fine, you can give your half of the story. Continuing on, the letter of the Office of Professional Responsibility, the Office of Professional Responsibility indicated that they conducted a thorough review of your claims and concluded they were without merit. Is that not true?
So they concluded that even if the investigations were motivated by animosity, that would still comply with the DOJ.
So my answer to my question is yes. In fact, what did the letter say? It said, from the OPR, it reviewed the submissions from the Whistleblowers Council and ATR, conducted its own review of the relevant laws, regulations, rules, policies, guidelines governing the issuance of second request, and reviewed publicly available information concerning the cannabis industry. OPR's review found support for the ATR's response. The cannabis industry provided a unique challenge to the federal and state regulators alike, and it was reasonable for ATR to seek additional information from the industry through its second request process. In addition, contrary to the whistleblower's allegations, the documents provided by ATR reflect significant and successful negotiations among ATR and the cannabis companies concerning the narrowing of the scope of the second request. Furthermore, the internal memorandum recommending the closure of the investigations reflect that ATR staff conducted a significant amount of analysis regarding the competitive impact of the proposed mergers and often explained how the actions of state regulators offset competitive concerns, basically undercutting the very discussion that you had in your opening statement. The concern even goes on further, and this is an interesting one. You wrote in your written testimony that the cannabis industry, you instructed the staff, quote, were not instructed to conduct interviews of customers. And that marijuana is not a Schedule I drug, correct? Is it a Schedule I or not?
I'm not sure exactly which schedule it's on, but it's on one of them, yes.
You were part of an antitrust in marijuana and didn't know how it was scheduled? And then we've asked to be part of this committee. Mr. Elias, the credibility of this is going downhill quickly here. Mr. Chairman, I mean, at this point in time, I'm entering into the record the letter from the Office of Professional Responsibility, basically clearing anything that was done in DOJ. I ask that it be submitted into the record.
Without objection.
I yield back.
Mr. Chairman, if I could respond.
The gentleman yields back. I want to note that Mr. Elias's political inclinations and job prospects obviously have absolutely no bearing on whether the serious allegations that he is making about the Attorney General are true. That is the subject of this hearing, and anything else is merely a personal attack and a distraction from the corruption he has uncovered at the department.
It goes directly to intent of the witness.
Why some members may want to change the subject, but I hope we will focus on the issue at hand. Mr. Cohen is recognized.
Thank you, Mr. Chair. It's interesting how all these things kind of come together. Today, a 3-judge federal panel, District Court of Appeals here, said that the Flynn case could be dismissed. And the person that wrote that opinion was Judge Rayo. Judge Rayo had been at OIRA, the agency that reviews regulations and does what Trump likes best, which is jeopardize the safe air and water of the American public and give in to industry and profits and pollution. And she did a good job of it. And the case she was most well known for was overriding President Obama's regulations on automobile exhaust. She became a judge a year ago. She said today, the district court's actions will result in specific harms to the exercise of the executive branch's exclusive prosecutorial power. If evidence comes to light calling into question the integrity or purpose of an underlying criminal investigation, the executive branch must have the authority to decide that further prosecution is not in the interest of justice. Well, I wonder, Judge Rayo, if who is supposed to look into the executive branch when what they do is not in the interest of justice? Well, it should have been Judge Rayo. It was one of the three judges, and maybe the full panel will review it. They should. The other way to do it is impeachment. Impeachment is the process by which, if the Justice Department and the executive branch are not pursuing the interest of justice, is the process left. And even if the ultimate trier, the Senate, is impotent to see the truth and to exercise discretion in keeping with the American public and with the rule of law, we should pursue impeachment of Bill Barr because he is raining terror on the rule of law. And it's questionable what he's doing. Mr. Mukasey, you said that there was an 1807 law, the Logan Act, and you disparaged it because it was an old law. Is that correct, that it was the one that was used to prosecute?
I did not disparage it because it was an old law. There are many old laws that are very fine. Our Constitution's even older.
You said that it was 1807, hardly ever used, and you disparaged it in the terminology that
I didn't use the specific law 1807. What I said was it has never been prosecuted successfully. It was prosecuted twice in the 18th and the beginning of the 19th century, both unsuccessfully, and that it is probably unconstitutional.
Well, thank you, sir. I'd just note that Bill Barr used an 1807 law, the Insurrection Act, to interfere with First Amendment rights so that the president could march through Lafayette Park and do his photo op holding a Bible in front of a church, not quote from the Bible, not lead people in prayer, but have a photo op in front of a church, a desecration of the Bible and a desecration of that church. So that was an 1807 law. Mr. Elias, you've testified as to cases that Justice and Antitrust took up concerning areas that otherwise you didn't think, or in the Justice Department superiors didn't think were worthy of antitrust investigations. One was cannabis.
That's correct.
Was that cost the cannabis folks a lot of money?
Absolutely. These subpoenas that get issued that require production of millions of documents is very burdensome.
So it was harassment by Bill Barr of an industry he didn't like. Is that right?
I think that's a fair way to characterize it, yes.
And ironically, that just like Judge Rayo, it all comes back to one place. Barr doesn't like marijuana. Marijuana is 7 times more likely to be enforced against young African Americans, breeding discontent with police and breeding interactions with police. And Barr doesn't care about that type of stuff because he doesn't like marijuana, so that's okay. That's one of the breeding grounds of distrust of African Americans and police and African American contact and problems. Great, very unfortunate. And you also brought up the antitrust case, which brings us back here with Judge Rayo on the antitrust with the automobile manufacturers. Did Mercedes-Benz not join in on that case later?
That's correct.
And why do you think Mercedes-Benz didn't join in on the case?
So I have read news reports that the German government discouraged it from joining because of the DOJ investigation. I don't have firsthand knowledge of those events.
So the likelihood is President Trump, who didn't like what Governor Newsom did, got his way and kept Mercedes-Benz out of it and was able to try to change them from taking their position to be similar. Let me ask, Mr. Mukasey, let me ask you this. Mr. Zelensky testified that for the guidelines where the defendant went to trial and remained unrepentant, in his experience, it was unheard of, especially like in Stone's case, in the lead up to the trial, we was told no one in the fraud and public corruption section of the United States Attorney's Office in D.C., which prosecuted that case, no time could he ever recall, or anyone recall, where the government did not seek guideline sentencings after trial. Do you know of any cases where the fraud and public integrity section did not seek guideline representation?
I do not, nor do I know of any case.
Thank you, sir. You
nor
don't,
do I know of
because
any
there is not a
case.
case. There isn't a case, but Bill Barr did it because Trump's friend.
Point of order. The witness was trying to
That
answer
was
the
not
question.
that was not a guideline recommendation. It was a travesty of a guideline recommendation.
I have the time, and I don't know who over there playing. I have the time. And this is a travesty
order.
because
The
this is
gentleman's
another
time has
case
expired.
where politics is overcoming the rule of law and destroying America. I yield back the balance of my time.
The gentleman yields back. Mr. Johnson.
Thank you, Mr. Chairman. Questions for Mr. Zelensky, if he can hear us on video. Mr. Zelensky, where are you physically located today?
I'm at my attorney's office.
What state is that, sir?
It's in the District of Columbia.
So how far are you approximately from where we sit right now?
I guess about a half mile.
And what's your reason for not appearing here today, sir?
Well, thank you for allowing me to clarify. As a prosecutor, particularly with the experiences that I've had in Baltimore, I'm reticent to discuss my family publicly, as we're
You have family
generally
concerns, is
trained
that
to do it.
right? Is that right? That's what you touched on earlier.
I have a newborn child, Congressman. My wife is a physician. We discussed the matter.
Okay,
I'm
fair enough.
actually on
Listen, I just wanted,
leave
listen,
right
my
now.
time, hold on. Mr. Zelensky, because you're an attorney, you know that having a witness appear and submit to cross-examination in person is obviously much more effective and reliable than one who simply phones it in, and we'll leave it at that. I just want to point out, the Honorable Judge McCasey, who showed up, flew from New York. He has family concerns as well. Many people do here as well. In fact, he's got to quarantine himself after this hearing because he has a young grandchild who's sick with other
The gentleman
it's my time.
the gentleman is improper. The witness is complying with the rules of the House. We make no distinction between people who are present physically and people who are present by video.
Mr. Chairman, it's my
period.
time, and it is not inappropriate, and you don't get to decide how I ask my questions.
Oh, yes, I do.
With all due respect. You said in your opening, Mr. Zelensky, that we don't prosecute people based on politics. The question is, do you investigate people based on politics?
No.
A couple of questions for you related to Inspector General Horowitz's report outlining the FBI's improper FISA surveillance of Carter Page. You're familiar with that, correct?
I have read press reports regarding it. I have read some of the report. I have not studied it carefully.
Do you know what role Christopher Steele played in the FBI's investigation of Carter Page?
I only know what's been publicly reported and what is in the Inspector General's report, Congressman.
If you're familiar with the report, then you must know that it states at page 359, quote, "We concluded that Crossfire Hurricane Team's receipt of Steele's election reporting on September 19, 2016 played a central and essential role in the decision by the FBI OGC to support the request for FISA surveillance targeting Carter Page, as well as the department's ultimate decision to seek the FISA order." Does that sound familiar?
I have no reason to doubt that you're accurately reading from the report.
What discussions did the special counsel team have about Christopher Steele?
Congressman, I have been asked by the department because of privilege not to discuss matters related to the special counsel's office. I am happy to go back to the department, as I have been told that I should do, to ask them if I can answer your question and to, if I am able to, provide you an answer at a later time. But I've been told by the department that my testimony today has been cleared only for matters related to United States versus Roger Stone.
That's pretty convenient. The subpoena that you were issued says you are hereby commanded to be and appear before the Committee on the Judiciary to testify at a hearing touching matters of inquiry committed to said committee or subcommittee, and you are not to depart without leave of said committee or subcommittee. The point is, Mr. Zelensky, it would be very useful to have you here. It would be very useful to have you speaking to the full scope of the concerns of this committee and things that we've been working on for a long time. And we think it's very unfortunate that you could not make your appearance here today, especially since you're a half mile away and others took great risks to be here. Look, not quibbling with you about family concerns, but a lot of people have them, and this is a very important matter for the country. I think we all agree to that. We have concern that this is being politicized, and that the current Attorney General's office is being accused of politicizing something when what he is trying to do is clear up and clean up messes that were made by his predecessors in previous administration. Everybody can look at the facts, I guess, and draw their own conclusions, but it would be helpful if we were able to draw them out. I won't yield.
The gentleman yield?
I will not yield. Because our problem with this is not only with the process, as has been stated, with the unequal administration of the rules here, but with the way that this committee's time is being used right now, with all the important issues that are within our scope of jurisdiction, with all the pressing matters facing the country right now. This is a farce. And we're really sorry that you couldn't be here for it in
Johnson,
person.
will you yield?
I'll yield.
I would just urge you to consider, when you say with all the pressing issues, is there any issue more pressing than the integrity of the administration?
Yeah, absolutely.
Of justice?
But
I mean, is there anything more
reclaiming my
important than
time?
making-
We would love to have hearings about the origins of the Russia collusion thing that you guys wasted the country's time on for 5 or 6 months on the sham impeachment. But don't get me started because I'm out of time. I yield back.
Ask John Bolton about the sham impeachment.
Not your time. Not your time.
Gentleman's time. The gentleman's time has expired. Mr. Johnson.
Thank you, Mr. Chairman. Mr. Zelensky and Mr. Elias, you put duty over country, and you have come to testify today, putting your job at risk. And I think the nation owes you both a debt of gratitude for coming forward as whistleblowers. Now, Mr. Elias, last summer, the state of California announced that it had reached an agreement with 4 automakers on air quality standards that would be stricter than the rules the Trump administration was preparing to adopt for the country, correct?
Yes, that's correct.
And when California announced that agreement, President Trump made clear that he did not like it, didn't he?
He did criticize the agreement on Twitter, yes.
And on August 20th, 2019, the New York Times reported that he was, quote, enraged by California's deal, end quote. Trump even apparently called a White House meeting to plot ways to retaliate, all because he resented the fact that California and the 4 automakers would dare to undermine his loosening of air quality emission standards. So the next day, August 21st, Trump went public and he threatened the 4 automakers, saying that these companies, quote, will be out of business, end quote, if they don't get in line. Then, the day after those tweets, August 22nd, President Trump's Justice Department followed through on that threat. That's when Assistant Attorney General Dal Rahim gave an instruction to your division to start an antitrust investigation immediately into those 4 automakers. Is that correct?
That is when the instruction to open the investigation happened on August 22nd, yes.
And so the president tweets out threats, and then the next day the automakers get hit with an antitrust investigation. That's what happened, didn't it?
And a point I would like to underscore is normally for significant, complicated matters, people put time and attention into assessing potential defenses.
But you didn't have any time to do that because the president made the order on August 22nd, on August 21st, and the investigation began on August 22nd.
There was very little time between those 2 events, yes.
Do you believe that the department commenced that investigation based on good faith belief that they had committed a violation of the antitrust laws or not?
So the career staff who examined it saw some very obvious defenses, things called state action, nor Pennington, and you really have to twist things to get around those. So it did not appear to be in good faith, no.
That investigation didn't have anything to do with protecting the American people from anti-competitive behavior, did it?
So the career staff who reviewed it had some grave concerns about opening it, especially the people who were then charged with actually conducting the investigation. They documented their concerns with the legal underpinning of the case, and if you're immune from eventual prosecution for something because you have a legal defense, you should be immune from investigation for having committed
And the law was clear that the state of California was immune.
So what I describe in my complaint is how staff was not given enough time to go through and properly understand the
And I wish I
defenses.
could give you a chance to explain more, but bottom line, it wasn't a legitimate antitrust investigation, was it?
That's what my complaint alleges, yes.
And if it had been, the first step would have been for the department to get with California officials and get the facts from those officials, but it never did even establish contact with California, did it, before it instituted the investigation?
That step is permitted even before an investigation. You could have resolved things even before opening the investigation, but it's correct. Yeah, to my knowledge, they were never contacted.
So what we have here is a clear-cut case of the antitrust division being made to respond to a president's tweet the day before to begin an investigation that had no basis in law or in fact. Would you describe that as an abuse of authority of the upper echelons of the Justice Department?
I did submit my complaint to the IG on the grounds that the events here constituted an abuse of authority.
All right, with that, I will yield back. Thank you.
The gentleman yields back. Mr. Jordan.
Thank you, Mr. Chairman. Mr. Zielinski, it seems to me you got just one problem. The judge disagreed with you.
Congressman, as I said, I'm not here to critique the judge's sentence. We
Well,
need to follow DOJ's
Mr. Zielinski,
policy.
you write a 13-page statement for your statement to this committee. You allege all kinds of politics. You go after the Justice Department, you go after Bill Barr, you go after the president. You file a sentencing memo on February 10th recommending 7 to 9 years. The very next day, your boss files a supplemental sentencing memo recommending 3 to 4 years. And 9 days later, Judge Berman Jackson picks the 3 to 4 year sentence. So the judge disagreed with you.
Congressman, I don't agree with the premise of your question on two levels. The first is the
Well, tell me what in that fact pattern. Tell me what in that fact pattern is wrong. Didn't Roger Stone get 40 months?
The supplemental memo, Congressman, did not recommend 3 to 4 years. It recommended a sentence of incarceration. The supplemental memo also mischaracterized other aspects of the guidelines.
Mr. Zielinski, I've looked at the supplemental memo, and it said 37 to 47 months. What was take away the enhancement, it said 37 to 47 months. Those were the numbers referenced in the memo, and Judge Berman Jackson picked 40 months. She didn't pick 7 to 9 years. Is that right?
She sentenced Mr. Stone to 40 months. That's correct.
And that's between 3 and 4 years. Exactly what was in the supplemental memo. Did you talk to Bill Barr about your concerns?
No, as I stated, I did not talk to the Attorney General.
You didn't talk to the Attorney. Did you talk to the DAG? Did you talk to the Deputy Attorney General?
Thank you.
I was not provided the opportunity.
Did you talk to Mr. Shea? Did you talk to the U.S. Attorney?
I requested to, but was not given a meeting.
So you didn't talk to any of the people who ultimately make these decisions, did you, Mr. Zielinski?
I requested to speak with the U.S. Attorney, but
I didn't ask you if you requested. I said, did you talk to him? You didn't talk to the Attorney General, didn't talk to the DAG, didn't talk to the U.S. Attorney. Who's the supervisor?
Which supervisor are you referring to?
I'm talking about the one you referenced about 6 times in your testimony. Page 2, it was told to me at the time by my supervisor in the U.S. Attorney's Office. You said, I was told that the acting U.S. Attorney for the District of Columbia, Timothy Shea, was receiving heavy pressure from the highest levels of the Department of Justice. Page 10 of your testimony, you say this, page 10, I was explicitly told that the motivation for changing the sentencing memo was political and because the U.S. Attorney was, quote, afraid of the president. Who told you?
Thank you for clarifying, Congressman. I just want to be sure that I get the right supervisor because there are a couple of supervisors.
Well, tell me all their names then.
That told me things. So the supervisor for the questions you're asking is the supervisor of the Fraud and Public Corruption section at the time in the U.S. Attorney's Office.
Who?
His name is J.P. Cooney.
All right. Who else?
At the time in the office, there was a first assistant, there was a criminal chief. They were all involved in these discussions, to my knowledge.
Did any of them talk to the Attorney General, the Deputy Attorney General, or Mr. Shea?
Yes. My understanding is they did.
Well, did it? Not understanding. Did they or didn't they?
Congressman, I can only tell you what I know. I can tell you from what I understand.
It sounds like you don't know much. It sounds like you heard stuff that you're now bringing to this committee as fact. So-and-so says to someone what they told someone else. And you bring that here as fact. Yet you didn't talk to the Attorney General, you didn't talk to the Deputy Attorney General, and didn't talk to the U.S. Attorney who made the decision. And oh, by the way, the judge sided with their supplemental memo, not the memo you signed.
Congressman, as I said, I don't agree with the premises of your question, and I'm happy to explain further involving sentencing. My understanding is that all of the people I mentioned, those supervisors, were all in meetings with acting U.S. Attorney Shea.
Well, I mean, this is as bad as this is as bad as the whole impeachment. The anonymous whistleblower who had no firsthand knowledge, was biased against the president, and who worked for Joe Biden. Now we have a so-called whistleblower with no firsthand knowledge, who didn't talk to any of the people who make the decision, and who's obviously biased against the Attorney General. It seems just as bad, just as lame as what we went through just a few months back. It seems to me, as others have pointed out, and I know my time is winding down, that the real politics here was in some of the investigations that took place prior. And when we have some time, I'd like to get into that as well, Mr. Chairman. With that, I yield back.
The gentleman yields back. Mr. Deutsch.
Thank you, Mr. Chairman. Mr. Zelensky, I'd like to follow up on Mr. Jordan's questions and ask about the severity of Roger Stone's crimes. He was convicted on 1 count of witness tampering and 6 counts of obstructing a congressional investigation by making numerous false statements. Isn't that right?
He was actually convicted on the 1 count of obstructing congressional investigation, 5 counts aligned to Congress, and 1 count of tampering with a witness, Congressman.
What did he lie about?
He lied, as I go over my written remarks, about a number of things, including what he was doing in the summer of 2016 related to WikiLeaks, and what he was telling the Trump campaign about it.
Yeah, he lied about providing information stolen by a foreign government to Trump's campaign. Isn't that right?
He lied about providing information to Trump's campaign regarding the WikiLeaks material.
Yeah.
That's correct.
Right. And were these minor misstatements, or did they impact the congressional investigation?
Both the judge found at sentencing and argued that they profoundly impacted the House Permanent Select Committee on Intelligence's investigation.
And the judge found that too. That's helpful. Roger Stone communicated with WikiLeaks and then lied when he said he didn't tell the Trump campaign staff, even Donald Trump himself. Isn't that right?
Mr. Stone lied about what he told the Trump campaign regarding WikiLeaks. That's correct.
Right. And what did Roger Stone do that threatened a witness, Mr. Zelensky?
He did a number of things. He had told the witness to prepare to die. He had threatened the witness's dog. He had threatened to harm the career of one of the witness's friends. He had written a slew of nasty messages to the witness.
And I know that we've been talking about these issues for a while. It's worth pointing out he told the witness to prepare to die. Did it appear that the threats worked? Mr. Zelensky, did they impact the witness's testimony?
They did.
And Mr. Zelensky, would you say that these are serious offenses?
Yes.
And help us understand, how did you come up with a 7 to 9 year recommendation? Did you follow the guidelines? Was it at the top or bottom of the range? And what were the enhancements that increased the sentencing range?
So in coming to the sentencing recommendation we do what we do in every case. We consult the PSR, which is a report that's prepared by the court. We consult the relevant Department of Justice policies, and then we look at the guidelines sentences. It's important to understand that the guidelines in this case were clear and the applications were readily apparent. It was not a tough calculation. After looking at that, we looked at what other sentences had been, and we determined what a reasonable sentence would be in this case.
Normally, the department defends recommendations within the guidelines range, don't they?
It is the policy of the department and reiterated memo in 2017 to seek guidelines recommendations in general.
But in your written testimony, you stated the team was pressured to submit inaccurate guidelines, inaccurate guidelines calculation that would result in a lower sentencing range. What was the nature of that pressure, Mr. Zelensky?
So there were meetings the members of my team had with leadership of the U.S. Attorney's Office and the acting U.S. Attorney, where he sought to get us not to ask for the guidelines that clearly applied.
And so you, after the pressure, you submitted your sentencing memo. Then the department leadership submitted a new sentencing memo for a lighter sentence. That's very much outside the normal practice in your experience, isn't it?
I think outside Democrats are not an accurate description. Unprecedented and virtually unheard of is what I would call it.
After your sentencing recommendation was overruled, you and your entire team withdrew from the case. Why'd you do that?
Because we took an oath to prosecute without fear or favor, and we weren't going to violate our oath.
Mr. Zelensky, it was political pressure that got Roger Stone a lighter sentence than he deserved. Mr. Stone got special treatment because of his connections to the president. That's not justice. The rule of law is supposed to mean equality under the law. Now, this case is a glaring example of Bill Barr corrupting DOJ, undermining equality in our legal system, and it's what's one of the reasons that we're here today. On Monday, you did your job and filed your recommendations to hold Roger Stone accountable. In the middle of that very night, the president tweeted, and Bill Barr's DOJ snapped into action the next day to take pressure off. That, Mr. Zelensky, is not justice. I yield back.
The gentleman yields back. Mr. Johnson. Mr. McClintock. Mr. Biggs.
Am I recognized there, Mr. Chairman? Mr. Chairman, am I recognized?
Yes.
Okay, thank you, Mr. Chairman. So I do find the setting for this to be deliciously ironic on the day that the Circuit Court dismissed the Flynn prosecution. Because you see, the Flynn case typifies the previous administration's abuse of the process for political reasons. I mean, you have a political appointee who is attacked, leveraged. They went after him for political purposes, used and abused the power and authority that they have. In fact, they knew it was bogus all along. I mean, even Peter Strzok's notes indicate pretty clearly that Director Comey acknowledged that General Flynn's phone calls with Ambassador Kislyak appear legit, and those were the basis for trying to invoke even the Logan Act. I mean, that's really kind of the way it is. But I thank Judge Mukasey for being here today. Judge Mukasey, the chairman indicated in his opening that he views Attorney General Barr as a fixer for President Trump. And yet, what we have here is Attorney General Barr saying that President Trump has never asked me to do anything in a criminal case and wishes that he would stop tweeting because it makes it impossible for me to do my job. Does that sound like a guy who's a fixer?
Sorry, not to me, sir.
Well, how about this? If you heard somebody say this, that I'm still the president's wingman, so I'm there with my boy. Does that sound maybe like more if that's coming from an attorney general, does that sound like somebody who may be more of a fixer?
I don't know about fixer, but if I had ever said anything like that when I was Attorney General, I would have expected to return to the department and find the building empty with a pile of resignations on my desk.
So that statement was made by former Attorney General Holder. And so my question is, we know that under Attorney General Holder, DOJ went after multitudes of investigative journalists. Judge Mukasey, have you heard or do you have any information whether under William Barr, for whatever reason, that he's gone after investigative journalists?
I do not.
Then we know that under that department, that Justice Department, they prosecuted whistleblowers. I know President Trump has expressed exasperation and disapprobation of certain whistleblowers and wished that they were prosecuted. Do you know of any prosecutions administered by this administration under William Barr of whistleblowers?
I don't.
We could go over a whole plethora of these types of things. Civil Rights Division, U.S. Commission on Civil Rights, they dismissed voter intimidation lawsuits. I guess my question for you is, do you know of any dismissal of voter intimidation lawsuits on the part of William Barr?
No, although I have to say I've not made a particular study of that area.
Fair enough. Fair enough. I don't know of any. The Fast and Furious issue. In that particular situation, Attorney General Holder would not come in for over a year to testify. Attorney General Barr has been in to testify. He's indicated a willingness to come back in and testify. The whole plethora of abuses by the previous administration's politicized Attorney General's office leads me to ask this question of my colleagues, and I think it's been typified of what we've seen here today. We've gone through here. There's been running over of the minority by the rules. It's really problematic. It really is problematic. If you want to know why this body, this group, this committee gets out of hand from time to time, people talking across each other, I'm going to tell you what it is. It's when you don't invoke and follow the rules, you become a little bit chippy. And that's what we have in this committee. And it's because we don't have the rules fairly and evenly followed. And that's the crying shame of this, Mr. Chairman. With that, I yield back.
Gentleman yields back. Mr. Richmond.
Thank you, Mr. Chairman. Mr. Chairman, let me just start by saying that part of our colleagues said that, the whole hearing is here so that we could embarrass the president. Let's just be clear. If we wanted to embarrass the president, we would sit back and do nothing and just let him continue to embarrass himself and say that you should drink bleach or disinfectant to cure COVID-19, that he slowed down testing, that it will magically go away, or the absurd statement that he has done more for black people than Abraham Lincoln. So in law, we just say res est pro loquitur, which means the thing speaks for itself. So instead of trying to embarrass the president, we would just let him continue to do it himself. What we're here today to talk about is the abuse of power and miscarriage of justice. So, Mr. Zelensky, let me just go to you. And I think that I want to follow up on what Mr. Deutsch was talking about, and that is to really understand why Roger Stone got such special treatment, but make sure we focus on the context of his crime. So what his crime was lying to Congress about his dealings with the Trump campaign, one of the convictions, right?
That was one of his crimes, yes.
And the summer before the elections, Stone told the Trump campaign that he had, quote, a plan to save Trump's butt, and he knew how, but to win, but it wouldn't be pretty. Do you recall that?
Yes, Congressman, I think you've replaced the profanity with another one, but that is correct.
Then also, Mr. Zelensky, what was Mr. Stone's plan?
Testimony at trial indicated that this was related to WikiLeaks.
And did you find evidence that Stone communicated with senior levels of the Trump campaign about WikiLeaks releasing stolen information about Trump's opponent?
Yes.
In fact, there are dozens of calls between Stone and the Trump campaign's top officials, right?
That's correct.
Also during that time, did you find evidence that Stone was talking to Trump directly?
Yes.
In fact, witnesses also testified that they were present when Stone spoke to then candidate Trump, right?
Mr. Gates testified to that at trial. Mr. Cohen testified to that for Congress, and Mr. Manafort told that to the special counsel's office.
Did you all find any records of these calls?
As I discussed earlier, it's difficult to know because we can't get content. We can only see call detail records when calls happened. There certainly are calls within that time period, but it's impossible to know the content. Only the people on the calls or anyone that overheard them would know the answer to that.
And why that's so startling is because President Trump's written answers to the special counsel He denied recalling having any conversations with Stone at all that summer. And he denied being aware Stone was having any conversations with WikiLeaks or anyone else in his campaign. Do you remember that?
You've accurately described the president's answers. Yes, Congressman.
Mr. Zelensky, have Roger Stone and Donald Trump been friends for over 30 years?
The evidence introduced at trial showed that to be the case. And Ms. Stone, and I believe the president has acknowledged that as well publicly.
So you found evidence from multiple sources that Roger Stone regularly communicated with the Trump campaign about the stolen information. You also found evidence from multiple sources that Roger Stone talked to President Trump, his friend of 30 years, directly during this time. And you have phone records corroborating all of this, but yet the president doesn't remember speaking to Roger Stone. And then when you recommend 7 to 9 years for Stone's crimes, all of a sudden your department gets pressure from the top to give Stone an unprecedentedly favorable treatment. Is that a correct characterization?
Congressman, I want to be very careful on how you describe the phone records that would give corroboration. We have call detail records. They don't give the full universe of possible calls because we only have them for the number that we have. So if, for example, a conversation took place on a line that we had not subpoenaed or someone else's phone, we wouldn't have them. And as I said before, we do not know the content of the calls. We know only what people testified. So I want to be very careful as to what we say about call detail records.
That's fair. But let me tell you, as a former defense attorney and lawyer, it's clear to me what happened here. Roger Stone got special treatment because he was covering up the president's misconduct, and the attorney general made it possible. The double standard here is absolutely sinful. If you're the president's longtime pal, if you're covering up his wrongdoing, you get special favors. But if you're peacefully protesting brutality, you get tear gas. With that, Mr. Chairman, I yield back.
The gentleman yields back. The committee will stand in recess for 5 minutes.
the window there. If you are talking to the American people right now, what would you tell them that they need to know?
Well, how long do we have? I don't think that I'm in a position to give a long discursive presentation on what they need to know. I think they're going to find out what they need to know in due course when investigations now underway run their course, and we'll find out what happened.
Are you concerned that there is a concerted effort to derail those investigations before they're completed and the truth is out?
Well, I don't know about derail because I don't think that John.
Well, these proceedings, for example.
These proceedings could have the effect of tainting the Attorney General and through him, John Durham. But John Durham has been at this for a long time. He had the faith of 3 Attorneys General at least, Janet Reno, me, my successor, and Attorney General Barr. That's 4.
Well, hopefully the truth will out and justice will be served. Thank you.
The gentleman's time has expired. Mr. Jeffries.
Mr. Mukasey, I respect you, but these proceedings are consistent with the United States Constitution. The House is a separate and co-equal branch of government. We don't work for Donald Trump or any other president. We work for the American people. We have a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. The Attorney General and the Department of Justice under his leadership is out of control. The Attorney General works for the people. He's not the White House counsel. It's the Attorney General and the Department of Justice should be an agent of liberty and justice for all Americans, regardless of political affiliation. Now, Mr. Zelensky, you testified that in the many cases that you've been privileged to work on during your career, you have never seen political influence play any role in prosecutorial decision-making, with one exception, United States versus Roger Stone. Is that correct?
That's correct.
And you were the lead prosecutor on the Roger Stone case, which included a variety of different criminal charges, such as lying to Congress and witness tampering. Is that right?
I was a lead prosecutor on the Roger Stone case.
And these were serious offenses, is that correct?
Yes.
They undermine the rule of law, true?
True.
Now, your prosecution team was pressured by the highest levels of the Department of Justice to cut Roger Stone a break. Is that correct?
That is correct.
And specifically, you were pressured to ask for a substantially lower sentence for Roger Stone than what you believe the facts justified. Is that true?
In addition to being pressured to misstate the guidelines, yes.
You were also pressured to distort the events that transpired during the course of the trial. Is that right?
Both during the course of the events leading up to the trial, Mr. Stone's criminal conduct, and some events in the trial itself, yes.
Can you give us one example of the type of distortion that you were asked to engage in?
So, for example, involving Mr. Credico, Mr. Credico was the witness that was intimidated by Mr. Stone. He both testified at trial and submitted a letter after the fact. The letter seemed to indicate that he wasn't as worried about the witness intimidation, but he had previously testified before the grand jury, and he also said at trial that he was concerned about what others might do as a result of Mr. Stone's actions. We were pressured to say that Mr. Credico had no concerns and expressed no worries as a result of Mr. Stone's obstructive conduct.
Now, the reason you were pressured to modify your overall sentencing recommendation was because of Roger Stone's close relationship with President Donald Trump. Is that correct?
That is what I was told.
And you were even warned that if you did not toe the line and give Roger Stone special and preferential treatment, you could, quote, lose your job, close quote. Is that correct?
That is correct.
You were also told that the acting U.S. attorney was giving Roger Stone favorable treatment because he was afraid of President Trump. Is that right?
Yes.
Notwithstanding this pressure, you refused to cut Roger Stone a break, and you filed your sentencing recommendation, which included 7 to 10 years in a proposed prison sentence. Is that right?
I believe the upper end of the range, the guidelines as we filed it, was 9, Congressman.
7 to 9 years. Just a few hours after your filing, the president tweeted that it was, quote, horrible and very unfair situation. Cannot allow this miscarriage of justice, close quote. Is that true?
Yes.
And the Department of Justice thereafter quickly filed a new sentencing recommendation for Roger Stone that reduced the number of years proposed that he would serve in prison for his crimes. Is that true?
Yes, it actually reduced the number of potential years to 0 because it said that he should have a sentence of incarceration, but it provided no information as to what that sentence should be.
Finally, the Department of Justice gave Roger Stone special treatment because of his close relationship with President Trump. Is that fair to say?
That is what I was told.
Thank you. I yield back.
Gentleman yields back. Mr. Gates.
Thank you, Mr. Chairman. Roger Stone should be pardoned. I believe Roger Stone will be pardoned. And then this proceeding will look even more ridiculous than it does today. I fear that my Democrat colleagues tend to behave the worst when they are caught. Undoubtedly, the Obama administration and their allies in the deep state were caught entirely off guard by the election of President Trump. They believed that their smears and coup attempts against him would be like an insurance policy in the event that you die before you're 40. They believed he should lose $100 million to 0. But then, of course, he won. And Democrats were caught yet again. This time, the DNC and the Hillary Clinton campaign colluding with Russia, utilizing a dossier that we now know had its subsources targeted by Russian intelligence. That's not a debate point. That is a finding by the Inspector General. And now we see House Democrats caught yet again with a failed impeachment, with the lack of an agenda. And as we sit here today, America's cities are burning, our monuments are being desecrated, our history is being presumably erased by people who are ashamed of the United States of America, and we have the audacity to have a meeting about the rule of law on a case that's already over, on an impeachment that has already failed, when there is real work for this committee to do. It's a joke. I yield to Mr. Jordan.
Thank the gentleman for yielding. I thank him for his well-stated comments. Mr. Zelensky, you took issue a few minutes ago when I said there was just one problem. The judge disagreed with you. I just want to read for the committee and for those viewing what Judge Berman Jackson said. She said, I agree with the defense and with the government's second memo. So she didn't agree with your memo, Mr. Zelensky. She agreed with the second supplemental memo and the defense team for Mr. Flynn. You also mentioned a few minutes ago that the supervisors. In your testimony, you said that you were told at the time by my supervisors in the U.S. Attorney's Office, and I didn't get those names. So if you could give me those names, I would appreciate it, Mr. Zelensky.
Congressman, I had earlier indicated that my supervisor, my immediate supervisor in the office, was the head of the Fraud and Public Corruption section. You asked me for his name, and I told you it was J.P. Cooney.
Okay, but you said, but your testimony says my supervisors. It's plural. J.P. Cooney. Who else?
There was the first assistant in the U.S. Attorney's Office.
And that is who?
Alessio. I will have to get back to you. Off the top of my head, I confess he's no longer the first assistant, so his last name escapes me at this moment, but I will tell you immediately when it comes to my mind.
Something
and then there's...
something this important, you can't even remember the person's last name who told you, and yet you're here in front of the committee as a so-called whistleblower, where the chairman of this committee has indicated that he wants to impeach Bill Barr. I mean, this is amazing. Okay, how about on page 10 where you said, I was explicitly told that the motivation for changing the sentencing memo was political and because the U.S. attorney was, quote, afraid of the president. Who explicitly told you that?
That was the That was the supervisor of the fraud and public corruption section that I referenced earlier.
Mr. Cooney, or the name you can't remember?
Mr. Cooney.
Okay, all right. Tell me about Joseph Mifsud.
And Congressman, if I could for a second, I apologize that it took me a moment to come up with the name. Alessio, the first assistant's name is Evangelista.
Okay, so tell me why the special counsel didn't charge Joseph Mifsud with lying to the FBI. He lied 3 times. You charge everybody else. You charge Gates, you charge Flynn, you charge Stone, you charge 13 Russians no one ever seen. We obviously know that the Flynn charge was wrong, as evidenced by what happened today. But why didn't you charge Joseph Mifsud, who lied to you guys back in February of 2017?
Congressman, I have been told by the Department of Justice that my testimony today should adhere to the 4 corners of the special counsel's office report. The privilege issues with going outside of that, I would be happy to consult with them, see if they will permit me to answer.
You were awful quick just a few minutes ago. Here's a sentence: Manafort told the special counsel. So you were fine talking to Democrats about what Manafort told to the special counsel. I'm asking you a simpler question. Joseph Mifsud, the guy who first tells Papadopoulos that they have dirt on the Clintons, Papadopoulos then tells the foreign diplomat who tells the FBI, and then we get this investigation that takes 3 years. And when you interview him, he lies 3 times. It's on page 192 of the Mueller report. I'm just asking you why you guys didn't charge him.
Congressman, I want to address your issue as to why I discussed what Mr. Manafort said.
The time of the gentleman has expired. Mr. Cistolini.
Thank you, Mr. Chairman. Mr. Elias, Mr. Aaron, Mr. Zelensky, you are courageous American heroes. Because of you and others like you, our Justice Department has been the envy of the world. Equal justice is a founding principle of our great country. Justice is done in every case without fear or favor, without party or politics. And we say in our Pledge of Allegiance, liberty and justice for all. Those words mean something. And in the face of staggering evidence of corruption, of misconduct, of lawlessness, we hear the same refrain from our colleagues on the other side of the aisle: you just don't like the president. But of course, the answer is we love our country. We love the rule of law. We love our system of justice, and we love the integrity of the Department of Justice. And we're deeply troubled by the testimony that's being presented today and what it says about this Attorney General and this president. And so, Mr. Elias, as a chairman of the Antitrust Subcommittee, I'm extremely troubled by the testimony that you have provided that confirms that the Trump administration has weaponized the department's antitrust division to reward friends and punish enemies. For years, public reporting has suggested that the Trump administration has been wielding antitrust in this abusive way, from the AT&T Time Warner merger, which the DOJ sued to block, reportedly at the president's direction, to the Sprint T-Mobile merger and Disney Fox transactions, both of which the DOJ smoothly approved despite serious anti-competitive concerns, allegedly due to personal ties that the CEOs and investors had to President Trump. So, Mr. Elias, I'd like to come back to the facts on why the investigation into 4 major automakers was ever opened, because there seems to be no evidence to support it. In fact, at a Senate hearing last year, the chief of the Antitrust Division told senators, and I quote, "I have nothing," when he was asked if he had any information of misconduct to justify this investigation of automakers. Your testimony today seems to confirm without question that there was, in fact, simply no basis to support the investigation. But I want it to be clear. Do you have any evidence that these automakers did anything wrong when they agreed to adhere to California's strict admission standards?
I would say that I think they had clear legal defenses for what they were doing under well-established antitrust procedures.
And was there any evidence that this investigation would in any way help the American people?
I'm not aware of any, no.
But there is evidence in your mind that this investigation was opened in bad faith to cater to the president's political whims. Isn't that correct?
I think the coincidence in time between the president's tweets and the instruction the next day to open the investigation could lead to the inference that you're describing.
And I'm correct in saying that the investigation was ultimately closed without any evidence of wrongdoing found, correct?
Correct.
Now, your testimony makes clear to me that this investigation was meritless. It had nothing to do with protecting the American people or American consumers, and everything to do with helping the president retaliate against automakers and support the president's feud against a specific state. And what's worse, the Attorney General used taxpayer money to do this. Mr. Elias, you've described an entire division writing a memo, an all-staff meeting, weeks and weeks of work. Given this investigation was clearly not about protecting the interests of the American people, am I correct that it still required the expenditure of significant resources?
It did require some staff time, some attorney time, and use of funds that did not ultimately yield a real violation.
So rather than pursuing meritless investigations to support the president's personal vendetta, the resources could have been used and better spent elsewhere. Do you agree?
I certainly agree, yes.
And finally, Mr. Elias, what has been the effect on morale in your division, given that the Attorney General is pursuing investigations based on the president's tweets and not on what is best for the American people?
Well, I do know that in the Federal Employee Viewpoint Survey, which surveys employees every year, the Antitrust Division is now ranked 404 out of 420.
Thank you. Mr. Ayer, I'd like to turn to you for a moment. The president is, of course, free to pursue an anti-environment agenda within the confines of the law, but there's a line between the department prioritizing executive policies and prosecuting companies and individuals solely to retaliate against the president's perceived political enemies. Can you just please describe the difference between the department prioritizing an administration's policies and what happened here? And what effect does it have on our justice system and democratic institutions if the president uses the department to attack those he disagrees with without legal cause?
The whole premise of a system of justice is that it will be brought to bear on the facts as they are and proceed pursuant to the best assessment that hard thinking and hard work can bring to it in terms of what action is appropriate. And the citizens of the country need to have trust that things are being done in an even-handed way for good reasons. The problem comes when there starts to be a widespread sense of concern or doubt that the government is actually taking often harsh actions, sometimes punitive and criminal actions, other times civil enforcement actions, or otherwise in civil cases acting in a way to help someone for special reasons that are totally unrelated to the public interest or any even-handed considerations. And then trust breaks down as it did after Watergate. And that's not a place we want to be as a country because order starts to deteriorate.
The time of the gentleman has expired.
Mr. Chairman, I have a unanimous consent request.
Gentleman will state his unanimous consent request.
Thank you. Mr. Chairman, I ask unanimous consent that this letter signed by over 1,100 former U.S. attorneys and Justice Department officials, both Republicans and Democrats, which strongly condemns President Trump and Attorney General Barr's interference in the fair administration of justice and calls on the Attorney General of the United States to resign, be made part of the record.
Without objection, Mr. Klein.
Thank you, Mr. Chairman. I want to thank our witnesses for being here. Mr. Zelensky, I wish you were here in person, but I want to ask you in particular, you've already been asked about the 13 of the 17 attorneys in the special counsel team, registered Democrats. What was Andrew Weissman's role in the special counsel investigation?
Andrew Weissman was a senior assistant special counsel, I believe was his title.
And were you aware that Weissman sent an email to then Deputy Attorney General Sally Yates saying he was, quote, so proud and in awe, end quote, of her after she disobeyed President Trump? Were you aware of that?
I'm familiar with that press report, yes.
Do you think this email compromised the appearance of an independent investigation?
I think that the attorneys in the special counsel's office did our job, and we did our job fairly and truthfully.
So you don't think that that email compromised the appearance of an independent investigation?
I think the investigation was independent, and I am not able to comment beyond the confines of the report, but I can tell you, Congressman, that we did our jobs and we followed the law.
So what did Special Counsel Mueller do after finding out that Weissman emailed that he was so proud and in awe of Deputy Attorney General Yates? He didn't remove him, correct? I'm sorry, remove her.
I want to be very careful.
No, remove Weissman.
I want to be very careful, Congressman, for the same reason that Congressman referenced earlier. I have I have to go to the department to be able to talk about matters that are outside the scope of the special counsel office's report and receive their permission to do so. The Department of Justice has given me permission today to discuss matters related to the Stone sentencing. They have not given me permission to discuss internal matters in the special counsel's office that are outside the scope of the four corners of the special counsel office's report. If you would like, I can go to the department and I will ask them for permission to
You've
answer your
spoken
question.
to things that you have read in the press or seen in the public sphere, correct? You've
I've
spoken to that earlier
confirmed,
today.
yes.
So are you aware that Weissman agreed to host a fundraiser for candidate Joe Biden's victory fund?
I've read press reports to that effect.
Okay. And are you aware of unauthorized press leaks coming out of the special counsel's office?
No.
Okay. Has the Justice Department Office of Inspector General ever contacted you about unauthorized leaks to the media?
They have not.
And are you aware if Justice Department Office of Inspector General has contacted anyone else at the special counsel's office about unauthorized leaks to the media?
I am not.
All right. With that, I'm going to yield to the gentleman from Ohio.
I thank the gentleman from yielding, Mr. McCasey. I'm going to take a look at this chart up here, because this is, in my mind, what politics at a Justice Department looks like. Hillary should win 100 million to 0. Trump's not ever going to become president, right? That's from Lisa Page to Peter Strzok. Peter Strzok responds, no, he's not, we'll stop it. Now, this is not just any old person saying, we'll stop it. This is Peter Strzok, deputy head of counterintelligence at the FBI, and the guy who ran the investigation into Hillary Clinton, codenamed Mid-Year Exam, and ran the investigation, Crossfire Hurricane, into the Trump-Russia, so-called Trump-Russia collusion. That's what politics at the Justice Department looks like, not what the Democrats are serving up today. Your response, Mr. McCasey.
Well, that's not the only exchange, I think, that suggests politics. In fact, there's one that hasn't gotten very much attention that occurred on the night that Ted Cruz withdrew and Donald Trump became the only candidate for the Republican nomination. And there was an exchange where one said to the other, I can't believe this guy is going to be the nominee. And the response was, this raises the pressure to terminate MYE. MYE was code for mid-year exam.
Mid-year exam.
How the candidacy of Donald Trump could raise the pressure to terminate MYE has been something that's mystified me ever since I saw that.
Yeah, no kidding. It shouldn't matter who the candidate is for the other party, determining what, how and when and why you close an investigation, finishing an investigation, or what you do in an investigation.
Right.
Yeah, thank you very much. Yield back.
Gentleman yields back. Mr. Swalwell.
Mr. Zelensky, on July 24 of last year, Special Counsel Mueller described in his testimony to this committee that there were identified gaps in his investigation that he could not account for. Do you recall that testimony?
I do.
And that includes lies, deletion of text messages, and obstruction of justice. Is that right?
That is what the Special Counsel's Office report says, yes.
And in our federal system, defendants are rewarded for accepting responsibility early in the proceedings for their sentence. Is that right?
That's correct.
Did Mr. Stone go to a jury trial?
He did.
Was he convicted at trial?
He was.
Was he also found to have lied to the judge during pretrial proceedings?
Yes.
And you made a recommendation with your team as to what the sentence should be. The president tweeted, and the sentence was ultimately lowered. Is that correct?
That's accurate.
So we have a pattern here. President Trump tweets, friends are protected. We saw that with National Security Advisor Flynn. He had secret conversations with the Russians before he was National Security Advisor, lied to Vice President Pence, lied to the FBI, and twice admitted that he had lied and pleaded guilty. Then comes Trump. He tweets repeatedly that this never should have happened. And Mr. Zelensky, the Flynn case has been dropped by the recommendation of the DOJ. Is that right?
That is my understanding from what I've read in the press.
But Donald Trump does not only protect his friends, he actually punishes his enemies. Michael Cohen, former lawyer to President Trump, charged with counts of tax fraud and false statements, pleads guilty early in the proceedings, testifies to Congress, and 9 days before his sentencing, Donald Trump tweets that Cohen wants 0 days in prison. He should serve his full and complete sentence. And Michael Cohen was sentenced to 3 years. Is that correct?
I don't remember Mr. Cohen's precise sentence, but I have no reason to doubt what you're saying.
So, Mr. Zelensky, you're a career prosecutor. You just want to follow the evidence. How does it make you feel as a prosecutor, and how does it make your colleagues feel when you see that your hard work and the evidence is being sidelined for political preferences?
Congressman, in the wake of the Stone sentencing motion, I heard from many assistant United States attorneys throughout the country, many of whom I did not know, about how disappointed they were with what had happened.
Why were you disappointed?
I was disappointed because we took an oath to do our job, to follow the law, to follow the department's policy, and to do what's right, and what happened here was wrong.
Has Attorney General Barr ever publicly mischaracterized findings from the Mueller report?
I can speak to the special counsel's office's report. I have not been authorized by the department to characterize the Attorney General's comments on it. I can ask the Department of Justice whether or not I'll be given authority to answer that question, and if permitted, I'll come back to you and answer.
Well, Mr. Zelensky, you give us hope. You have come forward, you're currently working in the administration, and you're doing it in the spirit of people like David Holmes, who testified during the impeachment inquiry, currently working as a political officer, people like Bill Taylor, people like Lieutenant Colonel Vindman, and then, of course, former officials like Fiona Hill and Marie Yovanovitch. And I hope that your courage today to talk about the political preferences shown in this prosecution inspires and begets future witnesses to come forward. But you did ultimately withdraw from the case and leave the D.C. office. Can you tell us why you did that?
I did that because what had happened was wrong, and I did not want to be a part of what had happened, and so I withdrew.
Thank you. And Mr. Chair, I would ask unanimous consent to enter into the record a bipartisan letter from 159 former Southern District of New York prosecutors expressing their extreme concern about the resignation/firing of Mr. Berman in the Southern District. And I would yield back.
Without objection, the gentleman yields back. Mr. Reschenthaler.
Thank you, Mr. Chairman. And I want to thank all the witnesses for being here today, especially those who had the decency to do so in person. So thank you. You know, I'm once again just absolutely disappointed, but not surprised, that my colleagues across the aisle are continuing to waste our time chasing ghosts rather than working for the American people. To assert that A.G. Barr, who's a serious law enforcement officer, he has a sterling reputation, to run around and say that he's interfering, he's running political interference for the president, it's absolutely laughable. A.G. Barr is cleaning up what are the ruins of the Obama-Biden DOJ. In particular, he's cleaning up from Jim Comey, who weaponized and politicized the FBI. And if you doubt me, just look at the treatment of former National Security Advisor Michael Flynn. Those were political abuses. That was political gamesmanship that was orchestrated by FBI Director Comey and what I call his merry band of never-Trumpers. Comey's FBI used the Logan Act. For those of you that don't know, the Logan Act is highly problematic, and frankly, it's likely unconstitutional. The Logan Act makes it illegal for U.S. citizens to engage in unauthorized foreign diplomacy. And despite this, the FBI used it, this archaic act, to set up General Flynn, even though they knew that he would never be charged with the obscure offense. In fact, since its enactment, the Logan Act has only been used twice to prosecute individuals, one in 1802 and one in 1852, and both were acquitted. So then why use this to go after Flynn? Well, according to the handwritten notes, the FBI's goal was, quote, truth/admission, or to get him to lie so we can prosecute him or get him fired, end quote. And around the same time the FBI was doodling these notes to set up Michael Flynn, around that same time, former Secretary of State John Kerry was holding meetings with the Palestinian Authority. Senator Dianne Feinstein had dinner with the Iranian foreign minister, yet neither of those individuals were even questioned about Logan Act violations. So clearly the charges against Flynn were politically motivated. And I should note that just this morning, an appeals court ruled the appeals court ruled in General Flynn's favor, ordering the dismissal of that case. So even if the DOJ recognized the Logan Act's futility, informing the FBI that it was not supportive of using the law to entrap it still used the law to entrap General Flynn. An FBI lawyer, in fact, testified before Congress and said the DOJ viewed the Logan Act as, quote, untested, and that the Logan Act would leave the DOJ vulnerable to, quote, substantial litigation risk, unquote. But that didn't stop Director Comey from using it to attempt to sabotage the Trump transition team. So if my Democrat colleagues want to accuse someone of politicizing the DOJ, they should start with Director Comey. Mr. Zelensky, what's your view of the special counsel's office toward the Logan Act?
Congressman, I'm sorry to sound like a broken record, but I have been told by the Department of Justice that there are deliberative process concerns with the discussion of the special counsel's office and what transpired there outside the confines of the report. I'm happy to discuss the special counsel's office's report, as I am happy to go to the department.
All right, Mr. Zelensky, I'm going to reclaim my time. How do you explain the discrepancy then between the treatment of General Flynn and that of Secretary Kerry and Senator Feinstein?
Congressman, I would need to consult with the Department of Justice before answering that question. If you would like,
right, I'm going to reclaim my time. Let's just switch gears and talk about Mueller's probe. You know, I was following it in the news, and it seemed like there were a lot of leaks during that time. Did you talk to the press during the Mueller investigation?
Never.
Do you know anybody that talked to the press?
I'm sorry, I'm not quite sure I get your question. And do I know of any person that has ever talked to the press, or do I know of anyone in the special counsel's office?
Yeah, that was working on the investigation. Did you know anybody on that team that was talking to the press?
Aside from our press relations professional, no.
Judge, in your time at the DOJ, did you ever use the Logan Act?
I'm sorry? No.
Why not?
I was never, I was never aware of any situation that could conceivably have been covered by it, and had I been, I think I would have been hesitant to use it because, number one, I believe it's unconstitutional.
Thank you. And Mr. Chairman, I yield my time. My time's expired.
Time of the gentleman has expired. Ms. Liu, Mr. Liu.
Thank you, Chairman Nadler. Let me set a context for why we are even here today. We're here because the Russians sweepingly and systematically hacked our elections in 2016. Roger Stone coordinated with WikiLeaks, who had the emails that Russian hackers stole from the Hillary Clinton campaign. Roger Stone also coordinated with members of the Trump campaign and spoke to Donald Trump himself. The Trump campaign embraced the stolen emails, planned their campaign messaging based on the Russian hack. And then after Roger Stone was convicted of multiple crimes, Bill Barr's Department of Justice intervened to lower the sentencing recommendation. That is a perversion of justice. I'm a former prosecutor, and it's clear to me that the only reason we were able to take the extraordinary step of locking people up in prison is because the people believe our processes are fair and based on the facts. One of the greatest dangers to democracy is when the people start believing their prosecutions are tainted based on who the defendant happens to know. And unfortunately, under Bill Barr's Department of Justice, friends of Donald Trump get breaks and special favors from the Department of Justice that no ordinary American could ever get. So my questions are for Mr. Zelensky. Mrs. Zelensky, before you worked at the Department of Justice, you clerked for Judge Thomas Griffith of the D.C. Circuit. He was nominated by a Republican president, correct?
That's correct. He was nominated by President George W. Bush.
And then you clerked also for Justice Anthony Kennedy, who also was nominated by a Republican president, correct?
President Reagan, that's correct.
And before you could become a United States attorney, you had to take an oath, and that oath was to the United States Constitution, correct?
When I became an assistant United States attorney as required by law, I took that oath. I actually had to take a similar oath on a number of occasions for various federal jobs that I've held, including the clerkships you just mentioned, Congressman.
So your client is not Donald Trump or Bill Barr. It is the Constitution of the United States and the American people. Isn't that right?
That is correct.
And on behalf of the American people, you and other career prosecutors submitted a sentencing memo of 7 to 9 years for Roger Stone. Is that right?
That accurately describes the sentencing memorandum, yes.
And when Judge Jackson viewed that recommendation, did she think it was supported by the record?
She did. She said that the sentencing memo that we had filed complied with all law, relevant DOJ policy, and practice, and was supported by the record.
After you submitted that sentencing recommendation, the President of the United States went nuts and said it was horrible, unfair. And then another memo was submitted by people above you. Were you told why they submitted that memo of a lower sentencing recommendation?
I was told that the U.S. attorney was taking action because he was afraid of the president. As I discussed, I was told that earlier, and I was told that there was heavy political pressure from the highest levels of the Department of Justice to cut Roger Stone a break.
Did any career line assistant U.S. attorney sign that lower sentencing recommendation?
None.
In the memo you had submitted initially, were you asked to remove portions about Roger Stone's misconduct?
We were.
Is that unusual?
I've never had it before in my experience.
Okay. Now, Mr. Mukasey has said that Attorney General could certainly ask for a sentence below the sentencing guidelines. But to be clear, that is not your problem with what happened. It's not that something was asked below the sentencing guidelines. It was a process, right, where the reason it was done was because Roger Stone was a friend of Donald Trump and the acting U.S. attorney was scared of the president. Isn't that right?
That is one of the problems. There were also flaws in the second sentencing memorandum that I believe should not have been submitted as well, besides the recommendation itself.
And do you believe those flaws were done because Roger Stone is a friend of Donald Trump?
I was told that the acting United States attorney was taking the actions that he was because he's afraid of Donald Trump. I was not told why the second sentencing memorandum was done the way it was because by the time it was filed, I had withdrawn from the office and I was not given the ability to review the materials, nor was I told who was writing it.
Thank you. And my last question. In United America, we do not prosecute people because of their politics. That's what you wrote. You also wrote, and we don't cut them a break because of their politics either. Was Roger Stone cut a break because of his connection to Donald Trump?
That is what I was told, and that is what appears to have happened to me.
Thank you, and I yield back.
The gentleman yields back. Mr. Raskin. Mr. Raskin. Unmute your microphone. Okay, Ms. Jayapal.
Thank you, Mr. Chairman. Mr. Zelensky, let's make this very simple for the American people. You testified today that you were told that the motivation for lessening the sentence for Roger Stone, the president's longtime friend, was because the U.S. attorney was afraid of President Trump. Is that correct?
Correct, among other things.
And in other words, sir, the Justice Department leadership based a sentencing recommendation not on the rule of law, not based on whether Roger Stone deserved the recommended sentence, but simply to appease the president. Is that right?
That is what I was told.
Thank you, Mr. Zelensky. I can see why the U.S. attorney was afraid to go against the president. U.S. Attorney Jeffrey Berman said that his investigations, including the president's close inner circle, would continue without fear or favor. And now he's gone. The rules are clear. The rules of this president and Attorney General Barr are clear, that is. Give the president's friends special treatment, keep your job. But dare to pursue justice, dare to follow the law, dare to hold the president's friends accountable, and you will be removed. But Mr. Zelensky, you went ahead with your sentencing recommendations in spite of these pressures and threats. Can you tell us why?
Because it was the right thing to do.
And you're there to do the right thing, and I appreciate that and your coming forward to discuss this. Mr. Elias, I'd like to switch topics and go back to the department's investigation of at least 10 cannabis companies to make sure we understand why you consider these to be sham investigations, investigations predicated on the personal interests of the Attorney General and the President, rather than the facts or a desire to protect American consumers. Approximately how many DOJ staff were pulled to work on these sham investigations?
Congresswoman, there were dozens of staff, attorneys, paralegals, economists, and others who worked on these various cases.
And these companies produced 1.3 million documents from the files of 40 employees at the DOJ's request. Is that correct?
That was just from the first of the 10 mergers, yes.
So potentially 10 times that if the same numbers were applied. And when the DOJ received these documents, is there any evidence that the entirety of these documents were even reviewed?
I think a very small number of the documents were reviewed.
A very small number. And in one of the reviews, some documents were never even uploaded. Is that correct?
They were uploaded after the closing process had been initiated, as if they were irrelevant to the investigation and its process.
So there were requested enormous resources, taxpayer dollars were used, these documents were never really looked at, they weren't relevant to the investigations. And so to be clear, at Attorney General Barr's direction, the department expends countless taxpayer resources to force companies to ultimately produce millions of pages of evidence and then doesn't even look at or upload some of that evidence before admitting there's a violation. Now, Mr. Elias, given your experience in public service, have you ever seen anything this extreme, using taxpayer dollars to conduct an investigation over the course of months on an entire industry and not even uploading evidence before admitting that there's no violation?
In my experience, which includes 14 years at the Justice Department at many different levels of the Antitrust Division, no, I've never seen anything like that.
And can you explain to the American people, why is that so concerning?
It's concerning because the investigations and the work of the Antitrust Division need to be done in good faith. They need to be done even-handedly, both for the sake of everybody involved and for the sake of the public's perception of the rule of law, and that the Justice Department is being above board with everything, calling balls and strikes as they truly are. So for it to disregard the usual standards and the law on what counts for an antitrust investigation is improper and an abuse.
Mr. Elias, you're just saying that the Justice Department should be pursuing justice.
Yes.
And I want to thank you for your bravery in coming here today. I think we all have to ask ourselves what this means for what we do not even know. This is a pattern that has been consistent. Bill Barr lied to the American people about the Mueller report. He ordered the military to tear gas peaceful protesters just so the president could have a photo op, and now is using the power of the Justice Department for corrupt purposes in these instances that we are investigating today. If he's doing all of these things, what else is happening that we don't even know about? Bill Barr appears to be a henchman for the president's likes and dislikes, not the Attorney General of the United States, pursuing equal justice under the law. He has abandoned his responsibility to uphold the Constitution. He is no longer working for the American people, and we must stop that. Thank you, Mr. Chairman, and I yield back.
Gentlelady yields back. Mr. Raskin. Okay. Ms. Demings.
Thank you so much, Mr. Chairman. Mr. Chairman, I care about the rule of law. I care about the oath of office that I've taken and that we've all taken, and what it means to take that oath of office to heart. Mrs. Zelensky, first of all, congratulations on the birth of your child. I also want to thank you for being a nonpartisan career prosecutor who treats people equally and fairly. Now, I believe that those would be welcome words, especially during this time in our nation when we're seeing civil unrest in all 50 states. A Justice Department that treats people equally and fairly. But we know that most people in our country don't have a fixer with the title Attorney General. Mr. Zelensky, in your testimony, I think it's so important that we keep our eye on the ball. We have heard so many distractions here today, but I'm committed to keeping my eye on the ball, to work hard to make sure that we do create a more perfect system of justice. Mr. Zelensky, in your testimony, you stated that political pressure resulted in the virtually unprecedented decision to override the original sentencing recommendation and the filling of a new sentencing memorandum that included statements and assertions at odds with the record and contrary to the Department of Justice policy. You went on to say that in the fraud and public corruption section of the United States Attorney's Office for the District of Columbia, you couldn't even recall a case where the government did not seek a guideline sentence after trial. Mrs. Zelensky, is that correct?
That's correct, nor could anyone else in the U.S. Attorney's Office recall such a situation.
So to be clear, that you could not recall it and nor could anybody else in that office recall it either. Is that what you just said?
Yes.
Thank you, Mrs. Zelensky. Mr. McCasey, during your confirmation hearing, you said, I appreciate these words, I served in the department in the U.S. Attorney's Office and SDNY for 35 years ago. I was never asked what my politics were. I did not know the politics of the men and women there, and still do not. And it did not matter. It had nothing to do with our job, nothing to do with the way we did it, and could not have anything to do with the job, and cannot have anything to do with the jobs of the people in the Justice Department today. As we find ourselves in this very critical moment, Mr. McCasey, do you stand by your statement?
I do.
And could you please explain to me why you do not feel that the Roger Stone case has anything, the decisions that have been made in that case have nothing to do with politics and have nothing to, do not compromise your position here today and the statement that you made during your confirmation?
Because the initial sentencing recommendation was wildly inappropriate, notwithstanding that it resulted from a mechanical application of the guidelines. The only person who determined the sentence in that case was the judge. She could have sentenced the defendant to any term of imprisonment or no term of imprisonment. She chose to sentence him to a term of 40 months, which was within the second recommendation. That second recommendation changed nothing so far as the bottom line result, because The judge is the only person who determines the sentence.
Do you believe that the president nor the attorney general, who has been acting more like the president's personal bodyguard and his fixer, have not engaged in politics as it pertains to the president's friends?
I can't speak for the president. The president is, by definition, a political.
Based on your professional decision, political or a professional experience, do you believe the president has engaged in a political way as it pertains to sentences or what happens to his friends?
The Attorney General himself criticized the president for tweets that he
So
said.
that's a yes.
It's a maybe. Go ahead.
Do you believe the Attorney General has engaged in politics in carrying out the president's wishes?
Short answer is no.
Mr. Chairman, I yield back. Thank you very much.
The gentlelady yields back. Mr. Raskin.
Thank you, Mr. Chairman. This is the most devastating testimony I have ever seen about an Attorney General of the United States corrupting the rule of law in pursuit of a political agenda for the President of the United States. And all of America can right now see exactly what's going on. The Attorney General, acting not as a champion of the rule of law or the Constitution, but rather as a sycophant and a consigliere for Donald Trump, has decided to go out and undermine cases, derail cases, and kill cases that affect Donald Trump's chosen ones, despite overwhelming evidence against them and despite guilty pleas by some of them. Now, it's going to take us a long time to sort out the full litany of unregistered foreign agents and liars and felons and frauds who have gotten a get-out-of-jail-free card by Attorney General William Barr at the behest of Donald Trump. And we should track all of that down. But more immediately, America faces two problems where Attorney General Barr is again threatening the rule of law and justice. And one is the public health response to the pandemic, which has now cost more than 120,000 Americans their lives. And the other is the fall election, which is the people's opportunity to speak, if allowed to do so, without election interference by foreign powers or by the government of the United States itself in an effort to intimidate and repress the vote. So I want to come to Mr. Ayer. In your testimony, you testify that Attorney General Barr has worked to, quote, create an authoritarian president. And I wrote down some of your basic points here. We obviously don't have time to get into all of them, but you say he undermined the work of independent fact finders, such as the FBI. He ignored and trampled Congress's powers under the Appropriations Clause. He categorically stonewalled congressional oversight and state criminal subpoenas. He attacked and undermined the inspectors general. He used political cronies to review and decide issues of special interest to the president. He reversed government positions in the Stone and Flynn prosecutions. He used the DOJ as a tool of the president's reelection campaign. He directed law enforcement forces to violate the First Amendment rights of peaceful protesters in Lafayette Square, and on and on and on, all the way to sacking Jeffrey Berman just a day or two ago. But among these things, you mentioned almost in passing that the Attorney General had tried to provide an echo to the president by likening public health orders by legitimate politically elected authorities in America, governors and mayors, to house arrest. And he said that he would work to jawbone the governors into rolling back public health orders put in place as the only mechanism we have to try to lower the death count and control this out-of-control pandemic, which is now ravaging Florida, Texas, South Carolina, Louisiana, Arkansas, large areas of the South and the West right now. What is the problem with the Attorney General deciding he wants to jawbone the governors and likening their policies to house arrest, which we all know is completely phony?
Your microphone, sir.
The whole issue of how do you deal with public health problems? Obviously, there are role for the federal government, and one that's not been performed terribly well in terms of coordinating overall supplies. But the basic decision-making with regard to how you're going to make the particular decisions of what people need to do, they're very local and they're very unique to local areas. And the judgments, I think everybody recognizes, basically are to be made at the state and the local level in terms of when to open, how much, in what ways, et cetera. And what appears to have happened here, and it didn't just happen once, it appears to have happened several times, is that Mr. Barr, and he really does appear to be echoing statements that the President has periodically tweeted and made about opening up. Obviously, the President's been very intense about wanting to get everything opened up. So Barr has echoed that and, essentially threatened. He's threatened to jawbone, but he's also in connection with the question about churches and whether churches are going to be treated in a certain way and are they somehow being treated less favorably than others. They've actually gone to court in some of those instances. Now, the Supreme Court rejected a challenge a couple of weeks ago with regard to one restriction on a church in California, and I have not heard anything about the Justice Department actually filing anything in connection with opening up issues concerning churches, but he continues to talk about the need to open up. And fundamentally, it's ironic to have a Republican administration intruding so far into such a sensitive core local government, state government question as local public health regulations dealing with the particularities of a case. So that's really—
Thank you, Mr. I want to ask you one other question, if I might, which is simply, he's also provided an echo for the President, who has voted himself by mail in New York and in Florida, and whose party encourages its members to go out and vote by mail. But he's echoed the President in saying there's something wrong with voting by mail, and he's alleged that voting by mail makes us vulnerable to foreign influence by counterfeit ballots. Is that an appropriate role for the Attorney General of the United States?
Well, I think it's not, and especially it's not because it appears to be something that there's absolutely no truth in at all. There are 5 states that do nothing but vote by mail, and every other state, I think virtually every other state, uses vote by mail somewhat substantially. And so the idea that we're going to throw cold water on the notion that we should use vote by mail, it's just disreputable. And it's entirely inappropriate. It really isn't his job anyway. If there were some law enforcement function there, it might be. But basically, he's just echoing the President, which is something he does more and more. And frankly, my worry is that he's going to do it more and more in the weeks and months ahead as we get closer to the election.
Do you think he's acting more like a campaign operative than like the Attorney General of the United States?
Well, as I said in my opening statement, I think he is, in fact, acting as an advocate for whatever fantasies the President wants to advance, one of which is this Obamagate nonsense that the members of this committee spew out as well. And he is now doing this, but the worst thing about it is he is doing it with the backdrop of an investigation which he has in his pocket. And nobody knows what that investigation is supposedly going to come up with, but he is hinting that he has terrible, incriminating things that he's found. And no one else is in a position to say he's wrong, but he is wrong.
The gentleman's time has expired. Ms. Lesko.
Thank you, Mr. Chair, and I apologize. I was in the Rules Committee hearing, and I'm here physically, so unlike members that are on both committees that are virtual, I have to actually physically come down here. You know, just from the short time I've been here, boy, it sure does sound like this is political speech going on here. But I yield my time to Mr. Jordan, the balance of my time. Thank you.
I thank the gentlelady for yielding. Mr. Mukasey, I want to read a statement to you from January of 2017 and get your response to it. It says, well, I'm going to ask you a couple questions about it. What's our goal? Truth, admission, or to get him to lie so we can prosecute him or get him fired? First of all, Mr. Mukasey, you happen to know who wrote that?
The name escapes me at the moment, but it was a senior FBI official.
Yeah, right. Director of FBI's Counterintelligence Division, Mr. Priestap, wrote that. Wrote this just prior to the interview of General Flynn. And what I want to know is that the kind of motivation that typically exists with investigators? Is their goal to get someone fired, to prosecute them? I thought the goal was to get to the truth.
That is supposed to be the goal.
And do you have concerns about that? I mean, Mr. Ayers just said it was nonsense to be concerned about things like this. He said, I think the term he used was we were spewing out things that were nonsense. This doesn't seem to me to be nonsense to be concerned about a senior official at the Justice Department, an important player in the investigation that was going on at the time that Peter Strzok was leading. Doesn't seem to me to be nonsense.
You're asking me whether
I'm asking you to comment. Go right ahead.
Okay. If that wasn't, the point is that wasn't an isolated example. It was one example among many, and that phenomenon of it being one among many, it's the many part that I think is a real concern.
Yeah, the many part. Couple that with the statements we just talked about a few minutes ago that I asked you about, that the two people in the FBI working under Mr. Priestep, one of them under Mr. Priestep, one of them for Mr. McCabe, the statements they had relative to the investigation, two important investigations. So it's the combination of all that. How about this fact? How about the fact that 38 people unmasked Michael Flynn's name 49 times? Just the volume and the number of different people. Does that concern you, Mr. McCasey?
Well, people who unmask are supposed to state the reasons, and I don't know what reasons they stated, but the sheer number would be of some interest.
In your time in working in government, did you ever see anything like that in your experience?
I did not. I was actually, truthfully, not involved in unmasking decisions or discussions, so I can't say whether and to what extent it happened. But it's supposed to happen only when it's necessary.
Your first impression as a former Attorney General of the United States, you see 49 different times, 38 people in a short time span. You get 6 people at Treasury, for goodness sake. 6 people at the Treasury Department unmasking Michael Flynn's name. Not just Clapper, Comey, Brennan, Biden, not just those individuals.
I want to know more about what the nature of their interest is and why it was necessary to disclose the identity of a U.S. citizen.
I do too. Mr. Elias, have you ever disclosed internal Department of Justice documents, including documents that might be privileged or confidential to anyone outside of the department?
I don't believe I have done that. I did produce my Inspector General complaint to this committee in response to its subpoena to appear here today. But that was a document that was my own words and not...
Why the hesitation? I mean, it's fine if you got the complaint relative to a so-called whistleblower, but is there hesitation because there's other documents you've disclosed?
I'm hesitating only because I want to be absolutely sure that I'm being truthful, and I cannot...
Did you give any documents to United States senators, Democrat senators?
I am fairly confident that I have not done that other than my whistleblower complaint. I don't believe that I've given I don't believe I've given internal documents to...
Have you ever worked at the White House?
I was on detail as a career Justice Department attorney to the White House.
What years? What time frame?
It was 2015, the first half of 2015.
Okay. Thank you, Mr. Chairman. I yield back.
Gentleman,
I have unanimous consent. I apologize, Mr. Chairman.
the gentleman yields back. Mr. Correa.
Could I do a unanimous consent?
The gentleman will state his unanimous consent.
Thank you, Mr. Chairman. I have a letter from the Justice Department to Senator Whitehouse from Assistant Attorney General Boyd dated June 19th, 2020.
That objection. Ms. Scanlon.
Mr. Elias, we've talked a lot about the politicization of the DOJ to serve the president's interests instead of the...
Your microphone.
I'm sorry, I'm just not close enough. You testified you believe the DOJ initiated certain investigations of the cannabis and California car industries because those industries were unpopular with Attorney General Barr and the president, and that you believe that this improper targeting undermines the public's perception of the DOJ as a fair administrator of justice. So this is essentially an allegation that instead of using the Justice Department to protect the rule of law and the American people, the Attorney General is using the DOJ to pursue the political whims of the president and expending public resources to retaliate against the president's enemies. Did you try to report those concerns to anyone, and if so, what happened?
So I've reported those concerns to the Office of Special Counsel, the Office of the Inspector General, and to Congress. And there was a referral by the Office of Special Counsel to the department. They found the initial review of the facts to be concerning enough that they thought the agency should investigate. And I should clarify, as a technical matter, there's a second whistleblower here, and it was her complaint that came in just before mine that was referred. The department sent it to the Office of Professional Responsibility, which conducted a review, and it came back with a report that, to my knowledge, was first circulated last night that I have read, and that had a number of issues that I was questioned about by Mr. Collins, Representative Collins earlier. What's curious about that report is it says that even if the allegations are true, even if these investigations were motivated by animus, and not by bona fide law enforcement reasons, then there's still no problem, that's not a violation of rules or regulations. And that's very concerning to me because it seems so self-evident that if your sole motivation is animosity, that's impermissible. If there is no rule or regulation, then there's sort of one missing because that's obviously wrong.
So essentially, the investigation that occurred didn't address your underlying complaint, which was that these investigations were politically motivated. It just found that no other laws were violated.
I think that's more or less correct, but it did say that even assuming they were politically motivated, that's not a problem, which is perplexing to me coming from the Office of Professional Responsibility.
So it's kind of like the argument that if a president has the power to pardon someone, it doesn't matter why he's pardoning someone, even if it's an improper use of that power.
I think that's a great analogy.
Thank you. Mr. Zelensky, you testified about another way that President Trump had weaponized the Department of Justice at the expense of Americans by using the Attorney General to help save his friends from punishment. You referred specifically to the case of Roger Stone, who was convicted on 7 counts of obstructing justice, making false statements to investigators, and tampering with witnesses. When you reported your concerns that the department was letting the president's political considerations interfere in the Stone sentencing, what were you told?
As I said in my statement, we reported our concerns on multiple occasions, but we were told that we could be fired if we didn't go along with it, and then we were told that this was not the hill to die on.
Okay. Our U.S. attorneys take an oath to protect and defend the Constitution and to prosecute without fear or favor. But we've been hearing testimony about attorneys like Mr. Zelensky and others resigning rather than violate those principles. And I think it's important that the American public know that this is not normal. Mr. Ayer, you've served in Democratic and Republican administrations. Have you ever seen this many career officials express alarm about the politicization of the department with no actions taken? Why is this such a problem?
I have not ever seen the number of letters that have been filed by, I think we're certainly in the thousands now of people protesting. I've never seen anything remotely like it in my entire life. And that's one of the reasons, that's one measure, it's only one. It's one of the reasons I say I think I've never in my lifetime been in as great a fear for the future of our rule of law as I am now, because it's happening across the board in a lot of areas, and people who know that system and are part of it realize how serious this problem is.
I mean, I think it's worth noting that where political corruption of the Department of Justice is coming from the top, from the President and the Attorney General, that resignation is the only way that career attorneys can ring the alarm bells, and we have to listen to them. I yield back.
Gentlelady yields back. Mr. Correa. Ms. Garcia.
Thank you, Mr. Chairman. The Flynn and Stone case both seem to follow a pattern. Attorney General Barr gives special treatment to the president's friends who break the law. Mr. Zelensky, Your colleague Jonathan Kravis, who was also assigned to the Roger Stone case, resigned from the department after 10 years because he said, quote, he believed the department had abandoned its responsibility to do justice in the Roger Stone case. Mr. Zelensky, do you agree with that assessment?
I do.
So Mr. Kravis wrote that after the Stone case, the department did the same thing with Michael Flynn, again putting, quote, political patronage ahead of the department's commitment to the rule of law. Mr. Kravis went on to say that prosecutors are not trained to comment on the sentencing, and it was, quote, not easy for him to do so. You also have said it pains you to have to describe these events. As a former judge, I can sympathize. Public servants are trained not to speak out, to let investigations and facts speak for themselves. But the department's actions are so shocking, such an affront to impartial justice, that all of you have been brave enough to come forward, and we thank you. And Mr. Kravis explained why. Because if Barr is able to get away with all of this, it will, quote, have lasting damage to our institutions. I'd like to read a copy of his op-ed, which, Mr. Chairman, I would like unanimous consent to enter the record. He said in his op-ed that he found it so compelling that it echoes the testimony today, Mr. Zelensky. He said, and I quote, in the Stone and Flynn cases, the department undercut the work of career employees to protect an ally of the president, an abdication of the commitment to equal justice under the law. Prosecutors must make decisions based on facts and law, not on the defendant's political connections. In other words, when the Justice Department makes decisions based not on facts and law, but a defendant's political connections, it betrays our system of justice. Mr. Zelensky, do you agree with this assessment?
I agree with the assessment about what the government needs to do, what it should do, and the impacts of abilities. I just want to be very clear, Congresswoman, I am not authorized to, nor do I seek to comment on the developments in the Flynn case.
Thank you. Mr. Elias, do you agree with the assessment?
Would you repeat the question?
The question is, in the op-ed, Mr. Kravis says that in the Stone and Flynn cases, the department undercut the work of career employees to protect an ally of the president, an abdication of the commitment to equal justice under the law. Prosecutors must make decisions based on facts and law, not on the defendant's political connections. So do you agree with that assessment?
I think with the general proposition that prosecutors have to make their cases based on their assessments of the facts and the law and not personal connections, yes, I agree with that.
Okay. Mr. Ayer, do you agree with that assessment?
Yes, I do.
Well, I do as well. And what's worse is that what Attorney General Barr did to the prosecutors who were brave enough to speak out, he publicly condemned them, despite knowing that they could not defend themselves. Mr. Kravis wrote that these actions, quote, send an unmistakable message to prosecutors and agents. If the president demands, we will throw you under the bus. Mr. Elias, what has been the effect on morale to think the Attorney General will, at the president's whim, throw employees under the bus?
Well, when you look at morale in the Antitrust Division, as reflected in the Viewpoint Survey, we are ranked 404 out of 420.
404 out of 420.
Yes, for agency subcomponents.
So you're down at the bottom.
Yes.
All right. Mr. Zelensky, how unique is this for a department to provide special treatment to a favorite friend and ally of the president over the recommendations of career attorneys?
It is, in my experience, unheard of.
It is unheard of. Well, it is unheard of, and we have also seen what he's done recently to Berman. The president and this attorney general have tried to send a warning to anyone who wants to speak out against the president, to anyone who is willing to stand up to them. We will throw you under the bus. Well, thanks to the brave testimony of some of our witnesses today, the president's tactics didn't work. The truth was exposed. The truth still matters. Thank you, Mr. Chairman, and I yield back.
Thank you. Now, Mr. Neguse is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you to each of the witnesses for their testimony today. I want to just first clear something for the record. Attorney General Mukasey, this is not your first time testifying before the House Judiciary Committee. Is that correct?
I believe that's correct, yes.
And in fact, when you were Attorney General under George W. Bush, you testified before the House Judiciary Committee twice. Is that your recollection?
Yes, at least 2 oversight hearings.
And if I'm not, if I believe it's correct, and you can correct me if I'm wrong, that your predecessor, Alberto Gonzales, when he was Attorney General, he testified before the House Judiciary Committee for an oversight hearing. Is that correct?
I have no idea. I mean, I
I
have no basis to challenge that. I remember my own appearances. I don't know about his.
Sure, I can tell you that it's accurate. I can also tell you, Attorney General Mukasey, that Attorney General Ashcroft testified before the House Judiciary Committee 4 times for oversight hearings. Attorney General Holder, Attorney General Janet Reno, they all have testified before the House Judiciary Committee. The only Attorney General who has not, in modern times, testified before this committee for an oversight hearing is William Barr. Are you aware of that?
Yes, and I'm also aware of the reason. He was supposed to testify, and that appearance was canceled by the chair, I believe, because of the onset of the COVID virus.
Well, I will tell you that that's not entirely accurate because there are prior requests for the Attorney General to appear before our committee that he declined. But nonetheless, I guess I'd ask you this, Attorney General Mukasey, do you know or can you name the last Attorney General who declined to appear before the House Judiciary Committee before Bill Barr?
No, I don't. I believe.
I can tell you who it is. It is Bill Barr, when he was Attorney General under President George H.W. Bush. So while I appreciate you being here and I certainly respect your service, and I think obviously our friends on the other side of the aisle deciding to call you here so that you could defend the Attorney General is within their purview, but I think it's important for the Attorney General of the United States to come in before this committee and testify. And while I am appreciative of the fact that it appears, based on the news today, that the Attorney General will appear before the committee, I think this committee needs to be prepared to use compulsory process and inherent contempt if necessary to ensure that the Attorney General appears before this committee. Now, I want to talk a little bit about something that we have not yet discussed today, which is the actions of the Attorney General regarding the peaceful protests in Lafayette Square. Mr. Ayer, as you're aware, at the direction of the Attorney General, peaceful protesters were forcibly removed from Lafayette Square after federal officers in riot gear fired gas, pepper spray, and stun grenades into the crowd. Now, Attorney General Barr has since claimed this was all pre-planned and not related to the president wanting a picture on the church steps. But the accounts of many officials contradict that, including the D.C. police chief, who stated, and I'll quote, "We heard that there was going to be an unscheduled presidential movement. Just a few minutes later, our teams on the ground learned that chemical munitions were going to be used. The munitions were deployed minutes later." The timing itself makes clear this was no coincidence as well. The clearing of the area began just after 6:30 p.m., and President Trump left the White House for the church around 7:02 p.m. So, Mr. Ayer, would you agree, would you agree, based on the facts, that the Attorney General's order to forcibly remove the protesters was not to protect public safety or uphold the rule of law, but so the president could get a photo op in front of the church on Lafayette Square?
Well, I obviously wasn't there, and I did watch it on TV. I guess I can't go quite that far, but I can go to the point of saying that Mr. Barr's several follow-up discussions have not covered him in glory. He's changed his story. The last thing that I think I understand is that he admits that he ordered the troop movement, but he said he did it, at least this is what I remember, he said he did it at 2 in the afternoon, and that the photo op wasn't until, like you said, early in the evening, and so he couldn't possibly therefore have ordered it in order for the photo opportunity because he didn't know about it at the time. However, he was there at the time. He obviously could have unordered it if he had wanted to. He also made rather strange comments related to what sort of eye irritants were used. He He tried to make some meaningful distinction between pepper balls or pepper spray or whatever it is and tear gas on the ground that one wasn't a chemical irritant. The whole discussion of him, to me, what exactly he ordered when, I'm not sure, but the one thing I'm absolutely sure of is that A, he was the one that ordered it, and B, his handling of it was such as to give us all enormous basis to distrust everything he says.
Well, let me ask the question this way. In all your years of public service, have you ever seen the Attorney General of the United States order the Park Police to violently clear with tear gas peaceful protesters?
Well, I haven't seen it, but I can't tell you for sure it never happened, but I'm certainly not familiar with it, nor am I myself familiar with instances where the Attorney General himself has assumed the role of sort of field marshal ordering police and troops around. I've never seen that. I'm not saying it necessarily hasn't happened,
Thank
but
you.
I'd love someone to tell me.
Thank you, Mr. Ayer. Your time
I
is
yield
up.
back.
Thank you. Before I recognize Representative Buck, let me just remind every member of this committee and people that are walking into this room that the guidelines have been set forth by the Office of the Attendee Physician and the House Speaker that members need to be wearing masks. And the chairman stated earlier very clearly that members will not be recognized if they are not wearing masks. Now, Mr. Buck, I will recognize you, but Mr. Jordan, I find it incredibly disrespectful that you have been sitting here next to the chairman without wearing a mask. You're putting other people's lives and their families
Every time I
in
speak
danger.
with the chairman, I put a mask on, I maintain.
Mr.
proper
Buck, you're
social
now
dis-
recognized.
Proper social distance.
Mr.
And-
Buck, you're recognized.
And the unmasking this committee should be concerned about is the unmasking that took place at the end of the Obama administration.
Mr. Buck,
But
would you
obviously
like your
not.
5 minutes?
Thank the gentleman for yielding. That is the unmasking we should be concerned about. 38 different people, 49 different times. 6 people at Treasury. What, 6 people at Treasury unmasking Michael Flynn? It makes no sense. I do think it's important to get back on the record here. The Attorney General was scheduled, as Mr. McCasey said, the Attorney General was scheduled to be here. Attorney General was scheduled to be here in March, and I believe he is coming next month. So he will be here to answer all our questions. I wish the committee would be as focused on getting Inspector General Horowitz here, as I said in my opening statement. Let's go back where I was earlier, Mr. McCasey. I want to look at something we learned today and view it in the context of that statement from Mr. Priestep, where he said, what's our goal? To get him fired, to get him prosecuted, to get him to lie. I want to view it in light of what we have learned today that took place just a few weeks prior to that. January 4th, 2017, we learned today that former President Obama, James Comey, Sally Yates, Joe Biden, and Susan Rice discussed the transcripts of Michael Flynn's calls and how to proceed further against him. Mr. Obama himself directed, quote, the right people to investigate Flynn. I'm reading from the supplement that was in front of the court last night, would help them, I think, make their decision. This caused former FBI Director Comey to acknowledge the obvious. General Flynn's phone calls with Ambassador Kislyak appear legitimate. And according to Peter Strzok's notes, it appears that the Vice President then personally raised the idea of the Logan Act. We've already discussed the Logan Act and how ridiculous that was, and the Vice President raising that at the time he did. But what I want to look at is this idea that Comey says there's nothing wrong with the phone calls between Mr. Flynn and Ambassador Kislyak, and yet 20 days later, and also, at that time, the FBI was ready to drop any proceedings, any case against General Flynn, but they decided not to. They decided to do basically what Mr. Priestep said. They decided to go after him, try to get him to lie, try to set him up. And 20 days later, Jim Comey, again, his words, not ours, Jim Comey sneaks 2 guys into the White House. I think you referenced this in your opening statement. Sneaks 2 guys into the White House, doesn't follow proper protocol, doesn't notify the White House counsel. That's the part that alarms me and I think should alarm any citizen. Your thoughts on all that?
Well, I've seen the summary of the Strzok notes that you mentioned. That just came out today, I believe.
Yep.
The timing, as you say, is disturbing.
Yeah, sure is. Sure is. Mr. Zelensky, you mentioned those 2 names, Mr. Cooney, and then give me the other name one more time because I want to ask you a few questions about these individuals.
Sure, Congressman. I believe the name that you're looking for is the former assistant For the U.S. Attorney's Office, as I indicated earlier, his name is Alessio Evangelista.
Evangelista, okay. Now, how many times, how many conversations did you have with these two individuals about the Stone case?
I just want to be clear before I answer. These are not all of the supervisors that I spoke with, but about the Stone case, I would say I spoke to them dozens, if not 50 times.
About the sentencing recommendation in the Stone case?
At least a dozen times.
After February 10th, after you filed it, or before?
Prior to February 10th, I'm sorry, you're asking prior to the filing
Look, you
memo?
file it on the 10th. There's a supplement the next day. The judge decides the supplement's the right way to go, not your approach. After February 10th, you said you spoke to Mr. Cooney and Mr. Evangelista about this, and they indicated that it was politics that were driving it. I'm asking you, how many conversations did you have with these two individuals after the 10th about the sentencing issue?
Congressman, I want to be very careful because I want to truthfully answer your questions to the best of my abilities. I did not have any conversations with Mr. Evangelista following the filing of our memo. The conversation that I outlined in my statement was with the head of the Fraud and Public Corruption section.
Okay, and that's when they told you it was politics that was driving the decision to change the sentencing recommendation. Is that right?
That was one of the times. I had previously been told.
Who did they get the information from that they passed on to you? Who told them that it was politics driving it?
I just want to be clear again, Congressman. When you say them, it was the head of the Fraud and Public Corruption.
Okay,
section,
who told him or her? Who told Mr. Cooney? Whoever that person is.
I know that he was in meetings with senior leadership. I do not know the source of his information.
So you don't know where he got it. He told you. You didn't talk to Barr. You didn't talk to the DAG. You didn't talk to Mr. Shea, but he told you, and therefore it has to be true.
The time of the gentleman has expired, Ms. McBath.
Thank you, Mr. Chairman. And I just have to say I've been extremely troubled by the events that occurred in our country, and more so by what we've been hearing today. And I'm heartened that our nation has, decided that they want to come together. But to come together, we need trust, and we need trust in our justice system. Some of my colleagues have suggested that you, our witnesses today, have come forward to testify for political reasons. And I do not believe that to be the truth. I believe that you are brave, independent public servants who have stepped forward to simply tell the truth. So I'd like to give each of you an opportunity very briefly just to tell us why you're testifying today. Mr. Elias, how long have you been a public servant, and what other roles have you held?
Thank you, Congresswoman. I have been a public servant since 2006, and I've held a variety of roles at the DOJ, including 2 stints as a trial attorney, a special assistant in the Office of Operations. I was in the Associate's Office with a few different roles there as well.
Thank you. So why did you feel, after all of your years of public service, that it was so important for you to come and testify before us today?
I looked at what was happening, which was unlike anything I had ever seen before, and didn't feel like a good faith calling of balls and strikes that I had been used to seeing. And I care very much about the antitrust laws, their even-handed enforcement, protecting consumers, and also the institution of the Antitrust Division, where I have spent my entire legal career. And when I saw these abuses, I thought that the public should get to know about them. So that's why I stepped forward.
Thank you, thank you so much. Mr. Zelensky, I'd like to ask the same questions to you. You've spent most of your career in the Department of Justice. Why did you feel so strongly about complying with our subpoena and coming before us today as well?
Because I took an oath to do so.
Thank you. Now, Mr. Iyer, most of us are familiar with your very extensive career in public service, and we're grateful to you for your service. But can you briefly explain why you felt the need to come forward today?
Yeah, so in the 10 or 11 years that I was in the department in 4 different positions, I was really inspired by the experience I had in a place where people really went to work to do the right thing. And processes had been put in place, a system was working People had a great deal of respect for each other and for the process, and it worked very well. And in the time I was there, I kind of moved up through various positions and ended as Deputy Attorney General. And it became clear fairly quickly, really, why it worked so well, and it was because of everybody being dedicated and these procedures being in place. I've known Bill Barr actually for about 40 years. I've never known him well, but I've always known that he was a person who had this idea that he really thought the president ought to be virtually an autocrat. I don't know where he got it, but that's his view. I was fearful when he got nominated this time, given that President Trump would like to be an autocrat too. And when he began doing the things he started doing, I became extremely concerned. So I've done what I could in terms of writing articles, and I'll continue to.
Thank you so much for that. What concerns me about the testimony that we've heard today is that career public servants are telling us what they're telling us. They're supporting facts and evidence and corroborating testimony that the Attorney General is pursuing cases based on political vendettas and not to protect Americans. I hope that the Attorney General would be here today. I hope to be able to ask the Attorney General about his actions attempting to reverse the ACA. I had hoped to ask him about what he plans to do to prevent gun violence from increasing during this crisis. I had hoped to ask him about the plans to ensure that all Americans have access to affordable health care, but he did not show up. So we need now more than ever, we need to come together, but we also need answers. And it's in times like these that when we're in crisis like this, these are the kinds of times that define us. These are the moments that define us. So, Mr. Chairman, I ask unanimous consent to submit a letter for the record from 33 former Antitrust Division employees who write that Mr. Elias is, and I quote, a person of integrity and a person who speaks the truth and fights to do what is right, end quote. They also state that Mr. Elias is, and I quote again, respected throughout the Department of Justice for his candor and his commitment to justice, end quote.
Without objection, the gentlelady yields back. Mr. Stanton.
Thank you very much, Mr. Chairman. There is deep concern that the Attorney General is using the Department of Justice to punish the President's personal and political adversaries. Such actions are a blatant abuse of our constitutional system. Perhaps even more troubling is that in doing so, the Department of Justice's resources are not being used to protect the American people. Our witnesses have provided evidence here today that the Attorney General is pursuing meritless investigations simply to appease the President. Mr. Elias, in your testimony, you mentioned the Department of Justice's investigation into 4 automakers in California who were trying to implement stricter air quality emission standards than those that the Environmental Protection Agency was going to adopt. In other words, they wanted to help clean our air. Is it correct to state that the Department of Justice used immense resources, including dozens of attorneys and staff, to pursue these investigations, even when career staff told leadership that there was no need to further pursue these investigations?
So the DOJ did use dozens of attorneys for the cannabis investigations that are also featured in my complaint. The emissions investigation was a smaller staff. But yes, public resources were used in pursuit of that investigation.
Does that seem like an appropriate allocation of resources to you, to commandeer immense department resources for investigations that career officials said were no longer necessary?
That appeared to be a gross misuse of resources between these various investigations, and that's why I made that allegation to the Inspector General and asked him to investigate gross misuse of resources.
Would it be fair to say that these investigations detracted from the legitimate work these attorneys could and should have been doing?
If these attorneys are working on that, that does take them away from anything else they could be doing that would potentially further the mission of the Antitrust Division.
Using department resources to appease others' activity fails to protect American consumers. In fact, such actions actively harm Americans by weakening the department's ability to prosecute legitimate antitrust claims. The American people would much rather see the Department of Justice investigate issues of grave concern to us all. For example, companies seeking to price gouge Americans by making them pay more for essential health products in the middle of a pandemic. Back in April, my colleague, Congressman Ruben Gallego, and I brought to light a price gouging chain taking place in Arizona. The City of Phoenix Fire and Police Departments were being charged nearly 600% more than the usual prices for N95 masks during a pandemic. Such egregious and completely unacceptable behavior requires the Department of Justice to use all of its resources to enforce our laws. What I find so troubling is that while the Department of Justice is spending time on illegitimate investigations, it could be working to fight real injustices in our system. Americans deserve a Department of Justice that serves the people and treats all defendants equally under the law, regardless of who they know or their political affiliations. And above all, they deserve a Department of Justice that follows the law. The testimony today continues to reiterate the urgent need for the Attorney General to appear before this committee. I look forward to having Attorney General Barr here in July because Congress and the American people have serious questions that need immediate answers. I yield back.
The gentleman yields back. Ms. Dean.
Thank you, Mr. Chairman, and I thank all of the testifiers, all four of our testifiers, for coming before us. I admire your sense of duty. I admire your giving of your time and your public service. America is counting on you. They're counting on Congress. They're counting on you, and I thank you for coming before us. Mr. Ayers, I'd like to go into a little bit more something that Jamie Raskin, Representative Raskin, brought up. The testimony today that most of you have delivered has confirmed what we have feared, that the Department of Justice is being used by the President and the Attorney General as a partisan political tool. It appears that Attorney General Barr's actions towards states amidst the coronavirus pandemic is part of the subversion of justice. We're in a pandemic, we're in a political year, an election year. On April 17th of this year, the President tweeted, and I quote, "Liberate Minnesota!" exclamation point. Quote, "Liberate Michigan!" exclamation point, and in all caps, "Liberate Virginia and save your Second Amendment. It's under siege," end quote. Shortly thereafter, Attorney General Barr, publishing a memo appointing the Assistant Attorney General for Civil Rights and the United States Attorney for the Eastern District of Michigan to investigate states' stay at home. Needless to say, that broad order included Minnesota, Michigan, and Virginia, the states the President had politically targeted. Mr. Ayer, Professor Ayer, is it standard practice for an Attorney General to bring action against states based on a President's political exclamations?
No, of course it's not. And I think in this instance, it's particularly unsuitable when the nature of the problem is really a genuine local problem that varies from place to place. But the pattern that you point out of Mr. Barr acting sometimes right after, but in any event, totally in a consonant manner with somewhat intemperate at times political expressions, usually tweets by the President, it doesn't just happen in this area, it's happening in a lot of different areas. The one I'm the most concerned about is the one that relates to this Obamagate nonsense that's being spewed by the President, and Bill Barr is echoing it now in TV appearances that are running about every 10 days. He goes on Fox News and he talks about his investigation and how people are going to get charged, and I don't know what's next.
I've seen that. I fear what's next. Even more concerning is that AG Barr has made clear he will use his powers to strong-arm states into doing what he wants regardless of the law. White House health experts publicly emphasized that removing stay-at-home orders prematurely, these are the health experts, prematurely could lead to avoidable death and suffering. Barr has, as my colleague raised, threatened to jawbone governors that's his word, who followed these public health recommendations. Mr. Ayer, in your written testimony, you explain that, quote, and I'll quote you, conduct limitations to protect the public safety in a health crisis are uniquely within the province of the state and municipal government, and they are choices that are highly local and tragically difficult. Do you believe the Department of Justice review of states' challenges, the Attorney General Barr's challenges to stay-at-home orders was motivated by a legitimate concern or constitutional overreach?
Well, I think it was constitutional overreach. I think it was a solution to a problem that didn't exist because the president wanted that interference to occur. That's what I think.
And it's certainly not my grandfather's Republican Party who believed states' rights were very important to protect, particularly in the area of public health. You even said that Chief Justice Robert wrote that our Constitution principally entrusts the safety and health of the people to the politically accountable officials, to the states to guard and protect. Is that correct?
That is right.
At the height of the global pandemic that shuttered 50 states, the President and the Attorney General conspired to use the might of the Department of Justice to punish states who took necessary actions. With my remaining time, just very briefly, do you believe Mr. Barr is fit to continue serving as Attorney General, yes or no?
No, I absolutely don't. I wrote an article about 8 months ago saying that, and it's gotten nothing but worse.
And finally, Mr. Zelensky, I too thank you for being with us. I have to tell you, it is not lost on me that in this committee we have hit a new low. When members on the other side of the aisle, mostly members who will refuse to wear a mask, attempt to paint you, they failed, but attempt to paint you in some negative light for staying in a remote location to protect a newborn child. I will say to you, what we believe on this side of the aisle is thank you for your duty, for your service, for protecting your family and your newborn baby. And I think the only thing we should have said in regards to your reason for not being here is congratulations on the birth of your baby. With that, I yield back.
Gentlelady yields back. Ms. McCarcel-Powell.
Thank you, Mr. Chairman. Mr. Ayer, I want to focus on Barr's handling of investigations into election interference. In Florida, we have serious concerns about the security of our elections. The Russian government hacked Florida's election system in 2016, and it is crucial that we ensure the integrity of the election process in November. But Attorney General Barr is not doing anything to make this happen. He called the special counsel's investigation into Russia's interference, quote, one of the greatest travesties in American history, and said that investigators were trying to, quote, sabotage the presidency, end quote. Let's be clear. The special counsel's investigation confirmed that Russia attacked our elections. Several people were indicted, including members of the Trump campaign, for lying about their involvement into Russia. The intelligence community and the Senate Intelligence Committee also confirmed the Russian hacking. Even Attorney General Barr said that, quote, I am confident that Russians attempted to interfere in the election, end quote. Mr. Chairman, I'd like to enter into the record this op-ed published in USA Today by Attorney General Barr on February 19, 2020.
Without objection.
Thank you. In the statement with FBI Director Wray, Barr lists Russia as a current threat. It says that an informed and discerning public is a resilient public, meaning we need to tell the public about Russia's threat. But AG Barr's words mean nothing because he's not here to tell the public anything. He and the president would rather attack the investigations into interference than protect our elections and prevent Russian interference. In March, AG Barr dropped the 2-year-long prosecution of a Russian company charged with conspiring to defraud the U.S. government. The company was organizing a social media campaign to interfere in the presidential election and is run by a man referred to as Putin's chef because of his proximity to Vladimir Putin. Mr. Ayer, does it concern you that the Attorney General is dropping investigations of Russian companies who have harmed us?
Well, I don't know the facts of the cases you're talking about, so I can't comment specifically. It does bother me a lot that I'm not aware that there's very much being done to deal with the problem of Russian interference in our election. And it seems to me there ought to be just an enormous priority on that, just as there should be an enormous priority on figuring out how people are going to be able to vote.
Thank you,
with the
Mr. Ayer.
coronavirus. So I'd like to see the priorities somewhere other than the wrong direction, which is some of the areas he's talking about.
Thank you. And, you know, the Attorney General knows that Russia is a threat, but he is dropping prosecutions against Russians who attacked us. What message does it send to other foreign threats like China or Iran if our Attorney General won't hold Russia accountable? Mr. Ayer, you wrote in your written testimony that AG Barr was, quote, actively undermining and subverting the role of independent fact finders who were put in place precisely so that the public can have trust in our justice system. Can you briefly explain this to us?
Well, it's a couple of different levels of activity. One is, you know, the statements he made with regard to the Mueller investigation, basically whitewashing the findings with regard to obstruction. That was the biggest single part. He just misled us about it. In December, when the IG investigation by Horowitz of the Russian interference investigation came out, and they found it was properly predicated and there was no bias in the oversight of it, Barr immediately went public and I think went on the media and announced he disagreed with that. So he actively intervenes and undermines conclusions, but he also acts to replace, to override, he has these processes he's put in place, including his own investigation, duplicative investigation of the Russian interference, and then these little things that come along like doing intake of information from Rudy Giuliani. Well, we'll just handle that in-house. We won't let the career people deal with that. There's a bunch of those.
I share your concern. This should not be about party politics. The stakes are way too high, and we all should be focused on protecting the integrity of our elections, Mr. Ayer. But when the integrity of law enforcement is corrupted, when men place themselves above the rule of law, nations fail. I can tell you that because I have witnessed it firsthand in Latin America. Governments filled with corruption devolve into chaos when politics are injected into the justice system. People lose their faith in their leaders, and I don't want that to happen in the United States of America. William Barr's actions is taking the Department of Justice down that path. His conduct is corrupt, dangerous, and it must be stopped. I yield back.
The gentlelady yields back. Ms. Escobar.
Thank you, Mr. Chairman. I want to close today by going back to what happened in Lafayette Square. On June 1st, Americans were shocked as they watched an incredible scene unfold. Here in Washington, D.C., peaceful protesters in Lafayette Square came together in protest, demanding change after watching graphic video of George Floyd's murder. They came together in protest, demanding change because of our country's horrific history of police brutality linked to racism. And on June 1st, while they peacefully stood in Lafayette Square, these peaceful protesters were overcome by mounted law enforcement and tear gas. Protesters, members of the media, Americans watching this at home were all stunned and wondered why. Moments later, as the president sauntered over to St. John's Episcopal Church, the story became more clear. We now know that in Lafayette Square, Attorney General Barr's department engaged in these tactics, forcibly removing protesters with tear gas and pepper spray, using stinger ball grenades, not to uphold the rule of law, not to protect Americans, but because the president wanted to pose for a picture. In other words, Attorney General Barr used the powers of the Justice Department to help the president's campaign film an ad. The president, rather than understand why he should feel shame for this, praised the horrific treatment of these protesters, tweeting, quote, "The protesters, agitators, anarchists, Antifa, and others were handled very easily by the Guard, DC Police, and SS. Great job," end quote. There was immediate nationwide outrage, including condemnation of this egregious abuse of power by Archbishop Wilton Gregory, General Jim Mattis, former Joint Chiefs of Staff Chairman Martin Dempsey, and Chairman Colin Powell, and a number of others. It couldn't be more clear that Attorney General Barr, as the president's chief enabler, is willing to lie and corrupt the department so that he can protect and promote the president's personal and political interests at all costs. We have heard today how Barr weaponized the Department of Justice to retaliate against states the president doesn't like. We have also heard today how the department is granting special favors to defendants who break the law, all because the U.S. attorney was afraid of President Trump. And he has reason to be afraid. We heard today what happens to prosecutors who stand up, like Mr. Zelensky, and say this is wrong. They are told to get in line or you will lose your job. And we've seen how true that actually is. U.S. Attorney Jeffrey Berman said his office would conduct its investigations without fear or favor. Investigations that we know go to the heart of the president's inner circle. And what happened to him? He was fired. We have confirmed today what we've known all along. The Attorney General is willing to corrupt our government, ignore our rule of law, and do whatever it takes to keep Trump in power, including subverting the upcoming elections. And Barr will lie to the American people if it helps the president achieve his goals. He cannot and should not get away with this. Mr. Ayer, I would like to end by asking you, with your decades in office as a public servant, what happens to our democracy if we do not hold Barr accountable? Can you describe what the effect is on the American people's perception of the Justice Department if our Attorney General is allowed to place the president's wishes above our rule of law?
Well, I don't want to get too apocalyptic, but I think if you want to just a real life microcosm of it, I think you go back and you look at what happened in Watergate. And in Watergate, we had a real failure. I won't go through all the facts, and some of you remember it and some of you don't, but the Justice Department failed, and the government justice system failed, and we were very, very lucky to have President Ford nominate Edward Levy as the Attorney General, and he saw the problem. The problem is one of trust. Not surprisingly, when the Justice Department and the justice system becomes untrustworthy, and that's the problem we're talking about here today. When it becomes untrustworthy, guess what? People don't trust it. And when people lose trust in the government and they lose trust in the law, then you don't have law. Then you have lawlessness. And you go from there, and you know what ends up happening. So it's very important that we recognize what's happening now. What's happening now is much worse than what happened in Watergate, much worse. It's across the board. It's a systematic effort to undo the checks that were put in place in Watergate and others that existed in the Constitution. And we need to do something about it. People need to stand up now and demand that something be done about it. This guy has got to go, and we need to get back on the track of having a system of justice where we care about doing it right and being fair and even-handed.
Thank you, Mr. Ayer. And sadly, this hearing demonstrates that Mr. Barr isn't the only enabler of President Trump. He unfortunately has way too many. Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. This concludes today's hearing. We thank all of our witnesses for participating. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.